that's post-COVID world.
Yeah,
Everything's empty.
exactly. Well, I have the things on the table to put up one day.
Yeah, right. Oh
Mhm.
gosh.
Yeah.
Let me see. I want to thank whoever makes these awesome cheat sheet lists. If it's Anna,
It is.
she's awesome.
She is, isn't she?
Yeah, I couldn't do this job without the help.
It is awesome.
I could, but it just takes a long time. When you work in court and you do the same thing every day and you work with the same people all the time, and it's kind of nice because now I'm beginning to know the people.
Yeah.
And the names are not, and everything isn't so, what's that acronym? You know, but it's still a little like that.
And be glad it's not 15 or 18 years ago when we did a lot of telecom.
Oh, those are hard.
And we used to say that like just AT&T would come up with 100 new acronyms every week. I mean, it was ridiculous.
Mm-hmm.
You know, I think there's probably people's job who it was to just make up stuff to confuse people.
Yeah.
And just so I'm correct, you pronounce your last name Gonsalves?
Nope, Gonsalves, like resolves.
Gonsalves. Okay, so
no thirds
at the end. Okay.
No, you do. You say Gonsalves.
Gonsalves.
Yeah, but it's Portuguese. It's been anglicized.
Okay.
So I mean, I don't know why my husband's family did that, but they did.
Well, you'll have discussion points with hearing examiner Medeiros.
Oh, that's true.
He is
Portuguese.
He is.
Yes, my husband's family was from a place called Madeira, a winemaking place in Portugal. Madeira.
Awesome.
Madeira. Yeah.
And I can't remember where Anthony's from, but do you have any questions about the procedure or?
No, I think this looks like it. So I'm guessing that this is not a lot of controversy since it cut down so much, is my guess. But yes. I've done a few of these now and they seem to go just, we're going to lay the foundation with each witness for the testimony. And then if there's any cross, we do the cross. And,
yep. And
then you ask questions if you have them and we just keep moving along.
Absolutely. And depending, I think as I indicated to you, depending on the parties, no party had any more than 30 minutes for any witness.
Yeah.
So like I say, I'm optimistic we'll get finished today.
That would be nice. But I've got marked off tomorrow too, if you need me. So there's
okay.
No problem there. Yep.
Very, very well.
And if we're close to the end of the day and you want to power through, that's fine with me too.
Okay, awesome. The way that I work is that if you get tired, you need a break, please let me know.
Okay.
And we will have a break. Otherwise, usually have one mid-morning, one mid-afternoon. I
think about it, an hour and a half is like that. Okay. Yeah. Awesome. That's pretty much like court does.
Okay, very well.
Oh yeah.
And
somebody just brought me some coffee.
Excellent. Well, I'm going to go ahead if there's no questions for us.
Nope. I think I understand it. I just like to make sure that I hear you well, and then I'll just kind of stand by and watch people come on and check them off my list.
Okay. And obviously, if I don't catch them quick enough, if they're talking over each other, please feel free to reprimand them and ask them to repeat or whatever. Okay.
Oh, very well. I can do that. Yeah.
Awesome.
Thank you.
I'll see you. I look forward to working with you. Yeah. Awesome. I will let the people in now.
Okay, perfect.
And
we can go from there.
Good morning, Miss
Gonzalez.
Lees.
Good morning. Can you
Yes.
all? Okay, great. I just wanted to make sure you could hear me.
Okay, you need to let Mr. Luth know I'm not going to let him in till he testifies.
You know, I did tell him that.
He's
I'll
gonna have to
Is-
go on YouTube.
I actually had a Zoom check-in with all of them to make sure the Zoom was working for everybody this morning, and I told them that. So I will text him right now and just remind him. He might be a little.
I didn't want him to think that I was ignoring him.
Yeah, I'll let him know.
And just a reminder, Miss Lees, we are on YouTube already.
Thank you. Yes, I got the reminder when I joined. Thank you.
Okay. And Mr. Contreras is the first witness, correct?
That's correct. I told him to sign on and that you might keep him in the waiting room until we're ready for him.
I just let him in.
Okay. I just didn't want us to have to wait for him to try and join. Yeah.
Well, in the parking garage, there is an Excel pickup truck.
Really?
Yep. So I thought, oh no, so someone's from Excel is coming to the hearing.
Nope.
Good morning, everybody.
Morning.
Good morning.
We've still got a few more people that okay, we're going to wait a couple of more minutes. We have, we're going to have a representative from CCAE and then Mr. Bagatko for staff. We're going to wait on. And while we're waiting, you see I have a nice wall like Mr. Bagatko does. We have, nothing. Well, if you look over to my left over here, there is a nice needle point that a friend of mine did of notorious RBG hanging up there. So that's the only thing that's in here. I'm getting an echo of myself that there's so little in here, but according to our court reporter, everybody say hi to Melissa Gonzalez.
Correct.
Is our court reporter. She's not hearing an echo, so hopefully you all are not hearing an echo. Oh, there's Mr. Bagatko. So we're going to admit him. He's connecting. Just everybody, friendly reminder. I think you get reminded when you actually get admitted, but we are live on YouTube and so I put that notice out there. Ms. Coleman, you need to remind Mr. Pollack that the witnesses can listen on YouTube, but I'm not going to admit any witness until it's their turn.
Yes, ma'am, I will.
Mr. Bagatko, your wall looks like my wall.
I'm just going plain Jane today. I'm sorry, I didn't have anything exciting to put up there for you.
Yeah, yeah. Do you see mine? That's the only thing on mine. A friend of mine did me a needlepoint of Notorious RBG.
Oh wow, look at that.
So that's the only thing on my wall.
Well, that looks like an immaculate, clean white wall.
Yeah. Do you echo back to yourself?
No.
No. Okay. Just me, I guess.
Do you want me
Okay.
to double check the connection?
No, you all don't hear it, so that's fine. Okay, looks like we've got our last party. Looks like I just admitted Miss Lynch. So I think we have everyone represented. And again, we are on YouTube. And just to let you know, and I don't turn that off even when we go on a break. So you might want to make sure that you act accordingly with that. Good morning. Happy Monday and welcome to our hearing in case number 21-172. Is anybody going to have anything that they need to put on procedurally that we need to discuss before we go on to the record?
Madam Hearing Examiner, only that we have a SPS Exhibit 1 that we'll need to enter into the record before we call our first witness, and that's our application.
Okay. Very well. Okay, hearing no other procedural matters, I don't really have any that I need to discuss. So Melissa, if you're ready, let's go on the record. And as I indicated before we went on the record, good morning. We are here today in case number 21-00172 UT. This is in the matter of Southwestern Public Service Company's annual 2022 Renewable Energy Portfolio Procurement Plan and requested approvals therein. Proposed 2022 Renewable Portfolio Standard Cost and Reconciliation Riders, application for an RPS incentive, and other associated relief. My name is Elizabeth Hurst. I am the designated hearing examiner for the commission in this proceeding. Along with me today is our court reporter, Melissa Gonsalves. And if anyone needs anything to do with the transcript, you will need to contact her directly. Pursuant to our pre-hearing on Friday morning, all the parties have emailed me their proposed exhibits. And if any exhibit that you offer here today is different than that exhibit, then you're going to need to let me know. And I think perhaps we should go ahead at this point and put our appearances on the record. And we'll begin with you, Ms. Lees, for SPS.
Yes, good morning, Your Honor. Zoe Lees and Will Du Bois on behalf of SPS.
Very well. And for the New Mexico Large Customer Group.
Good morning. This is Austin Rushoff on behalf of the New Mexico Large Customer Group, joined by my colleague Nick Stoffel.
Very well. Good morning. And Ms. Coleman for Occidental.
Thank you, Your Honor. Katie Coleman and Michael McMillan for Occidental Permian Limited.
Good morning. And for CCAE, Ms. Lynch.
Good morning, Your Honor. Kara Lynch, attorney for Coalition for Clean Affordable Energy.
Also referred to as CCAE.
Correct.
Very well. And Ms. Drake?
Joan Drake for Louisiana Energy Services, also known as LES.
Thank you. Good morning.
Good morning.
And Mr. Bagatko for staff.
Thank you, Madam Hearing Examiner, and good morning, everybody. John Bagatko for the New Mexico Public Regulation Commission Utility Division staff.
Great. Today is the date, time, and place for the hearing in this matter, as I set forth in the procedural order that was issued in July 23rd. And also pursuant to that procedural order, SPS was required to perfect mailing, publication, and web publication. And they have done so pursuant to their notice of filing of affidavits of mailing, publication, and web publication that were filed with the commission on August 26th of this year. I'd also like to note for the record that the hearing examiner's assistant and paralegal, Ms. Kippenbrock, who is the official person in the notice to contact to give public comment, received no request to give any public comment in today's proceeding. So unless we have any other procedural matters that we need to deal with, I would believe we will go ahead, Ms. Lees and Mr. Dubois, and if you would like to begin the evidentiary portion of our hearing here today.
Madam Hearing Examiner, if I may, apologies for my interruption. I just wanted to request permission to be excused to come and go from the hearing.
Yes, ma'am. Thank you, Ms. Drake. I do recall that you indicated at the pre-hearing on Friday that you may need to be excused periodically from the hearing today. You don't have a witness, and on Friday had indicated that you didn't know if you were going to have cross or not. And you do understand, Ms. Drake, that if you are not present when your turn comes up, you lose your turn to have any cross and or participate in any procedural discussions that we have, correct?
I understand that, and I understand that I would waive any objection to any rulings during that time as well.
Very well. Unless anyone has any objection, and I hear no objection, then your request is granted, Ms. Drake.
Thank you, ma'am.
Very well. And you may go ahead, Ms. Lees.
Thank you, Your Honor. Before SPS calls its first witness, I would like to enter into the record SPS Exhibit 1. It is the application and proposed notice that SPS filed in this matter, and it is as it appears on the docket.
And Ms. Lees, this is in fact the bear with me just a second. This is the exhibit that you emailed, SPS Exhibit 1. Is that correct?
That's correct, Your Honor.
Okay.
I can't see the bottom of this PDF page, but I assume it has our exhibit sticker on it.
Okay. Let me go back and share. Looks like I've shared my picture of Machu Picchu, which just for information purposes was taken exactly 10 years ago. And my 78-year-old mother was zooming up and down. All of those different levels. Whoa, that's way big. Okay, Ms. Lees, how about that?
Yep, and if you just scroll down, I can confirm that.
There you go.
Yep, that's
Okay.
the one.
All right, any objection to what's been identified as SPS Exhibit 1, which we could take administrative notice of it being in the record, but for efficiency's sake, I will go ahead and admit that exhibit if we don't have any objection. And hearing no objection, SPS Exhibit 1 is admitted.
Thank you, Your Honor.
Ms. Lees?
SPS next calls its witness Mario Contreras.
Okay. Good morning, Mr. Contreras.
Morning.
And Ms. Gonzalez, would you like to swear Mr. Contreras?
Yeah. Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Before we begin, Mario, it seems like we're getting a little bit of feedback from your microphone. Can you maybe say testing 1, 2, 3 so we can see if we're getting static still?
Is that better?
That is better. Thank you.
Thank you.
Can you please state your name for the record?
Yes, my name is Mario Contreras.
Thank you. And do you have in front of you what has been marked as SPS Exhibit 2?
Yes, I do.
Can you identify that document for the record?
Yes, that is my pre-filed direct testimony in this case.
Do you have any corrections to make to this docket?
I do not.
This document, excuse me. Thank you.
No, I do not.
And if I were to ask you the same questions contained in this document today, would your answers be the same?
Yes, they would be.
And are those answers true and correct to the best of your knowledge?
Yes.
Next, you have in front of you a document marked SPS Exhibit 3.
I do.
Can you identify that document, please?
Yes, that is my rebuttal testimony filed in this case.
Do you have any corrections to make to this document?
I do have corrections. The first one is on page 15, line 15. The reference there is needs to be replaced. The correct reference is 62-16-5 62-16-5B2.
And I'll represent your honor that that correction is made in the exhibits that were circulated to you and the parties in this case.
So, Mr. Contreras, basically you're just replacing the 4 with a 5?
That's correct, Your Honor.
Okay. Go ahead.
And do you have any other corrections to make to this document?
Yes, I do. On each page, page 1 through 34, the header should read rebuttal testimony. So replace the word direct with rebuttal.
And I'll also represent that that change has been made to the exhibit that was circulated to you, your honor, and the parties. Mr. Contreras, if I were to ask you the same questions contained in this document today, would your answers be the same?
Yes.
And are those answers true and correct to the best of your knowledge?
Yes.
Okay. Madam Hearing Examiner, SPS moves Exhibit 2 and SPS Exhibit 3 into the record.
Mr. Contreras, your direct testimony, SPS Exhibit 2 contains some attachments, correct?
Yes, they do, Your Honor.
And did you produce those attachments, or were they produced under your direction and control?
Yes, they were.
And were there any corrections, additions, or deletions to those attachments?
No, they're not.
Okay. Any objection to what's been identified as Mr. Contreras' direct testimony as verified by him here today? Hearing no objections, SPS Exhibit 2 will be admitted. Mr. Contreras, you filed rebuttal testimony and you corrected your rebuttal testimony. I do not believe you had any attachments to that testimony. Is that correct?
That is correct.
And are there any objections to SPS Exhibit 3, Mr. Contreras' rebuttal testimony as corrected and verified by him here today? Hearing no objection, SPS Exhibit 3 will be admitted. Ms. Lees?
Yep, we passed this witness for questioning, your honor.
Very well. And as indicated at the pre-hearing, cross-examination order will be in the order that the parties intervened, which means cross-examination will begin with the New Mexico large customer group, then Occidental, CCAE, LES, and then staff. So, Mr. Rushoff, any questions for Mr. Contreras?
Yes, I have a few questions.
Go ahead, sir.
Okay. Good morning, Mr. Contreras.
Good morning, Mr. Rushoff.
We've met before, but just again for the record, I'm Austin Rushoff, representing the New Mexico Large Customer Group. As you may have guessed, I have a few questions for you regarding the financial incentive that SPS has proposed in this proceeding. And I'm going to be referencing the Renewable Energy Act, which we have marked and shared with the parties as NMLCG2, as well as Commission Rule 572, which we have also marked as NMLCG3. So I just want to make sure you have those available for you this morning.
I do have those.
Thank you. So as I mentioned, I want to start out a little bit just kind of generally discussing the Renewable Energy Act, or REA. The REA is the basis for SPS's request for a financial incentive in this proceeding. Is that correct?
Yes, that's correct.
And another of the bases for your request for a financial incentive is Commission Rule 572. Is that also correct?
That's correct.
Mr. Contreras, would you agree with me that in both your direct and rebuttal testimonies, you describe what you see as a conflict between the Renewable Energy Act and the cost benefit analysis that's part of Commission Rule 572? Is that correct?
Yes, and specifically 572 22D.
Correct. Yeah, thank you. So I want to explore your perceived conflict between the statute and the rule a little bit in a few questions. Mr. Contreras, would you agree with me that as a general matter, the REA promotes renewable energy, but also recognizes that renewable investments will cost utility customers money?
Can you repeat that, please?
Sure. I'm asking, would you agree that as a general matter, the Renewable Energy Act promotes renewable energy investments, but it also recognizes that such investments will have financial or cost impacts to utility customers?
Yes, I'd agree with that.
Okay, and thank you. And specifically, I'd like you to look at NMLCG 2, which is the Renewable Energy Act. And Hearing Examiner Hurst, I don't know if it's your preference if we pull that up on the screen or not.
You should be seeing it.
I just still see Machu Picchu, which is lovely, but.
Okay. Let me try again because it says I'm sharing. So stop the share. Go back to the share screen. How about now?
Yes.
Okay.
You see it? Okay. And Mr. Contreras, I'd like to point you to the section that's actually on the screen right now, section 6216-2. And that section of the REA is labeled findings and purposes. Is that correct? Do you see that?
Yes.
And if we could scroll down to subsection B, which I believe is at the very bottom of this page. Yeah, there, that's perfect. There it says the purposes of the Renewable Energy Act are to, and then if you look at subsection 3 there, which is on the next page, it says protect public utilities and their ratepayers from renewable energy costs that are above a reasonable cost threshold. That's you see that in the statute. You agree with me there?
I do.
Okay, and then I'd also like to point to REA section 6216-4. Should be a couple pages down on this exhibit. I'll represent that 6216-4 is the section of the REA that's specific to the renewable portfolio standard. And then if we can scroll down to subsection B3. Just, Mr. Contreras, you would agree that subsection B and then 3 at the top of that page speaks to the renewable portfolio standard and the prevention of unreasonable impacts to customer electricity bills. Is that correct?
That's correct.
Okay. Thank you, Mr. Contreras. And with these two sections of the REA in mind, would you agree with me that the REA generally provides for a balancing between customer rate impacts and the goal of increasing renewable energy resources?
Yes, that's correct.
Okay. And would you also agree with me, just as a general matter, that the commission has a duty to ensure just and reasonable rates for customers?
Yes, I agree with that.
Thank you, Mr. Contreras. I'd like to change directions a little bit here, and I'm going to refer to your rebuttal testimony, specifically page 8. If you have that in front of you.
I do.
Okay. And beginning on line 9 of your rebuttal testimony, page 8, you state there, sort of in the middle of the line, utilities have been eligible for incentives throughout the time of SPS's construction and procurement of renewable generating stations. Is that correct?
That's correct.
Okay, and then if you could flip a page or two over to page 10 of your rebuttal testimony.
On there.
And then on line 12, middle of the line again, similarly, you state almost all renewable procurements on SPS's system were built before the passage of the ETA, with the knowledge that SPS could be eligible for incentives for an incentive under the existing statute.
That's correct.
Did SPS seek an incentive when it applied for an CPCN for the Hale and Sagamore wind facilities?
No, it did not.
Okay, but SPS is now seeking a financial incentive, and that financial incentive is, at least in part, based on retiring RECs associated with the Hale and Sagamore facilities. Is that correct?
It's yes, that would be included. It's based on retiring RECs from all of our generating and procurements.
Sure. And as we've discussed before, now Commission Rule 572 includes a cost benefit analysis relating to the award of financial incentives, correct?
For the specifically for carbon emission reductions. That's correct.
And would you agree with me that the inclusion of a proposed incentive, if it were included in the Hale and Sagamore CPCN proceedings, would have changed the cost benefit analysis of those wind facility investments at that time?
I can't speak to that. I don't perform cost benefit analysis. That'd be more for Mr. Elsey and Ms. Lieb. I get the information from their calculations.
Okay, maybe I could ask the question sort of a different way. Would you agree that a financial incentive that is based in part on retiring Hale and Sagamore RECs would add costs to customers associated with the Hale and Sagamore facilities?
I think in general, an incentive awarded would add a cost paid for by the customer.
Thank you, Mr. Contreras.
I'm sorry, Mr. Rushoff, part of your questions are breaking in and out. I'm having a hard time hearing the whole question.
Okay, I apologize for that. Just if something's not clear, please let me know and I can restate the question.
Thank you.
I'm going to ask you a few questions now about Commission Rule 572.
Okay.
Which is again marked as NMLCG 3, if you want to have that available to reference. And Mr. Contreras, previously you referenced 572-22D, which contains the cost benefit analysis in this rule related to financial incentives. And just to clarify, SPS has requested a variance from that 572.22D in this proceeding. Is that correct?
That is correct.
And in your testimony, you state that using SPS's own proposed calculations and methodology, SPS's proposed financial incentive fails the cost benefit analysis provided in 572.22.D, correct?
I'm sorry, where are you at in my testimony?
I can point you to your direct testimony, page 42.
Okay.
Sorry, I'm on the wrong page. And looks like on line 6, the question is, do the analyses provided by Mr. Lieb and Mr. Elsey show that the benefits of achieving the goals set out in subsection B are not exceeded by the costs it incurred to achieve them? And your answer is no. Is that correct?
That is correct.
Okay. I'm going to jump back to your rebuttal testimony. Page 30. And line 6, if you can let me know when you're there.
I'm there.
Okay. On line 6, there's a sentence there that says, however, the commission has the inherent authority to judge whether the incentive proposed by SPS is fair to customers. Do you see that?
Yes, I do.
And I think midway through that sentence, the word is inherent, but I believe it's inherent might have been what you intended. Is that correct?
Yes, that's correct.
Okay. Would you agree with me that the commission was exercising this authority when it implemented the cost benefit analysis provided in Rule 572?
I don't necessarily agree with that. The incentive, the section D specifically, is all about carbon dioxide emissions reduction. The REA statute and the rule itself allows for an incentive, or for a utility to ask for an incentive specifically for exceeding the public utilities annual RPS requirements. And so if you look at section D, as I explained in my direct and rebuttal, when we're the proposal that we've made is solely for that first part. If you look at section 22B1, that is the basis for SPS'S incentive request in this case. So looking at section D, we're not, and Ms. Leave can explain this more in her assessment, we're not asking specifically for carbon dioxide emission reductions. We're simply asking for exceeding our RPS requirements for the years 22, 23, and 24.
Thank you, and I understand. But would you agree that the commission has the authority to require a demonstration of carbon emission reductions to grant an incentive?
In regards to section B2, I would agree with that, but I do not believe that it's in line with the section 22B1, which is what we're basing our incentive request on.
Okay, thank you. And just to clarify, it's your position that the company.
I'm sorry, Mr. Russo, I didn't hear the first part of that.
Sorry. I think I can move to questions related to REA section 62.16.4D. Just want to make sure you have that available, and I apologize if I'm breaking up.
Tell me again, sir, what section?
This is the REA 62.16.4D.
So you want to go back to exhibit 2?
That would be great. Yes, thank you.
Okay.
And I'm there whenever the hearing examiner gets there.
Okay, I think that's what you wanted.
That looks great, thank you.
Okay, Mr. Rushoff, I don't know what's happening. It's your audio. So I don't think it's that your questions aren't clear. It's that your audio keeps dropping, and I haven't been able to identify that you're dropping your head or what, but it's your audio that's drifting in and out.
I may,
There you go. Now I hear you.
I'm good.
You are.
Okay, I just have a couple more minutes, so let's see if we can get through this. I can try headphones as well if that might help, but Mr. Contreras, we're looking at subsection D of 62.16.4, and this is the section of the REA that SPS relies on for its financial incentive. Is that correct?
Well, yes, that's correct.
Okay. And if you can look at that section, it says upon a motion or application by the public utility, the commission shall, or upon a motion or application by any other person, the commission may open a docket to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the RPS. And then it goes on. Do you see that language?
I do.
And you would agree with me, Mr. Contreras, that in this proceeding, SPS is not requesting to produce or acquire any additional renewable energies. Is that correct?
That's correct.
Okay. And in fact, SPS's incentive proposal is based on retiring banked RECs or renewable energy certificates. Is that correct?
Yes, it's based on retiring RECs in excess of the 20% requirement.
And this subsection D in the REA, it doesn't specifically reference any incentives related to retiring banked RECs. Is that correct?
No, but it does reference, as you read, encourages public utilities to produce or acquire renewable energy. And so what our incentive proposal is doing is we will be retiring these RECs, as I explained in direct testimony and rebuttal. We'll be retiring these RECs in excess of the 20%, which will bring forward, as Mr. Elsey explained, the need to acquire or purchase renewable energy earlier than would otherwise be necessary.
Thank you. And again, just to clarify, the need to purchase or acquire additional renewable energy in the future is at this point a projection. SPS has not actually proposed any new acquisitions. Is that correct?
That's correct.
Okay. And Mr. Contreras, the banked RECs that SPS plans to use to exceed the RPS, SPS customers have already paid for these RECs. Is that correct?
So those are matched with the energy that's already been produced. So yeah.
Right. So they've paid for the RECs through either base rates for the generating facilities or through PPAs that SPS has. Is that correct?
Yes.
Okay. If you could please now turn to page 47 of your direct testimony. Specifically the question that starts on line 9.
Down there.
So that question on line 9 says, what would be the result if the variance requests are granted? And this is the variance request for Rule 572, the cost benefit analysis, correct? Is what you're talking about here?
That's correct.
Okay. And then beginning on line 12, in answer to the question, you state SPS will retire RECs early in order to meet the 2025 40% standard in plan years 2022, 2023, and 2024. And SPS customers and New Mexicans will receive the benefits as identified in section 62.16.2 of the REA of the resulting increased renewable energy on SPS's system and decreased emissions. Is that a correct representation of your testimony there?
It is.
Mr. Contreras, would you agree with me that specifically in plan years 2022, 2023, and 2024, when SPS proposes to retire excess banked RECs, SPS customers and New Mexicans will not receive the benefits of increased renewable energy and decreased emissions. Is that correct?
That is correct, although the benefits of the reduction it occurs on an annual basis with all the generation. If you're looking at just the generation portion, we, as demonstrated in attachment MAC 3, Appendix A, you can see that the generation that we have, renewable generation we have, far exceeds any requirements that we have. The RA itself allows for the banked RECs up to 4 years. And so we, as also stated on Appendix A, page 1, we use a first in, first out on REC retirements for those purposes of meeting the RPS requirement.
Thank you. That's helpful. And just to clarify, the related specifically to the banked RECs, the benefits of increased renewable energy and decreased emissions already occurred when those RECs were generated, correct?
Specifically for the reduction of emissions, those benefits have been realized, yes.
Okay. And if SPS's request for a financial incentive is granted, and SPS accelerated the retirement of RECs it has already banked, the potential benefits of increased renewable energy and decreased carbon emissions would not actually materialize until SPS actually produces or acquires additional renewables after it exhausts its banked RECs. Is that correct?
If you're looking solely at the emissions reductions, yes. However, as I state here, Section 62.16.2 identifies multiple benefits that the legislator wants to look at when initiating the RPS standard and when you're looking at exceeding the RPS requirement as well. Specifically, if you look at A1, 2, and 3, there's plenty of, or specifically A1 and 2, that identifies all of the benefits to New Mexicans that the RA has and exceeding the standard would also produce.
Sure. Thank you.
Well, let's go through those then, Mr. Contreras. What you're saying that if we look at 1, 2, and 3 of 62.16.2 Section A, is that correct?
Yes, I'm sorry, I meant to say 1 and 2 identifies the benefits of the REA and the RPS requirements and exceeding the requirements.
Well, specifically related to your testimony, that, and based upon your answers to Mr. Rushoff's question, that with the proposal to use banked RECs for a 3-year period, that you're not going to be getting any decreased emission benefit. And you're claiming that if the commission grants you the incentive for those 3 years, you're saying that one of the benefits of doing that is going to be Section 1, the generation of electricity through the use of renewable energy presents opportunities to promote self-sufficiency, preserves the state's natural resources, and pursue an improved environment in New Mexico. Is that correct?
Yes, that's correct.
Well, how is using up 3 years of banked RECs gonna accomplish that?
As I mentioned earlier, and as I mentioned in direct testimony, bringing, and also as Mr. Elsey states, operating under just meeting the minimum requirements, we don't have to bring on renewable energy until the 2030s. Being able to retire early to meet the 40%, we will, as the RA states, it's providing an incentive and encouraging SPS to procure or purchase renewable energy much earlier than anticipated.
So okay. And then you also say section 2, the use of renewable energy by public utilities subject to the commission's oversight in accordance with the Renewable Energy Act can bring significant economic benefits to New Mexico. If the commission were to grant you an incentive to utilize banked RECs, is using banked RECs going to bring significant economic benefit to New Mexico?
Again, I point back to the bringing on renewable resources earlier than would otherwise be necessary. And so these would be large utility scale resources to be able to meet the requirements. And so that could provide economic benefit to New Mexico.
In the 3 years, which you haven't proposed any new renewable, to utilize any new renewable resources?
So in the 3 years, we're specifically asking just to exceed that. So it's more in general that the outcome of what we are doing is providing that the economic benefit to New Mexico.
So are you saying if you use up all your banked RECs, then you're going to have to go get new renewable, and then that's going to satisfy that second condition?
Yes.
Okay. And don't you think, Mr. Contreras, that if the legislature had wanted everyone to achieve 40% compliance in 2022, 23, or 24, that they would have mandated that particular standard?
They very well could have, but very clear they encourage utilities to exceed that standard. And if you look at 62.16.4E, the last sentence in that paragraph states when a public utility can generate or procure renewable energy at or below the reasonable cost threshold, it shall be required to do so to the extent necessary to meet the applicable renewable standard and shall not be precluded from exceeding that standard. And that last portion, the shall not be precluded from exceeding the standard, was not in the RA prior to the passage of the ETA. So the combination of section D and E is encouraging utilities to exceed the RPS standard. And exceeding the RPS standard of 20% could mean 30%, it could mean 40%. So we are proposing to meet the 2025 standard of 40% instead of something smaller or even greater. It's the 40% that we wanted to look at for the next, for the incentive purposes.
Well, sir, if you think that the combination of those two allows you to exceed, why not go for 50 or 60%?
I don't have an answer specific to that. I just know that our incentive proposal is to reach the 40%.
Okay. Thank you, sir. Go ahead, Mr. Rushoff.
So as we were talking about, Mr. Contreras, SPS is not proposing to acquire or produce any new renewable energy in this proceeding, correct? They merely propose that may happen in the future.
It will happen in the future as detailed by Mr. Elsey. It's just it would happen earlier than otherwise would be necessary if granted the incentive.
Thank you. That's helpful. And again, just to clarify, I understand that Mr. Elsey has stated that SPS projects it will need additional renewables in the future. But again, that is simply a projection at this point. There's no specific plan on the table, correct? To acquire.
Yes, that's correct. And Mr. Elsey can explain that in more detail.
Thank you. If SPS's proposal to accelerate the retirement of RECs is approved, and SPS does produce or acquire additional renewables at some point in the future, SPS customers will have to pay for those additional renewable investments and rates. Is that correct?
To the extent that the costs are prudent and approved by the commission, yes, any procurement of renewable resources would be paid for.
Okay, so you would agree with me that while there may be a benefit of increased renewable energy and decreased emissions when SPS acquires additional renewable resources in the future, there will also be, to some extent, a cost to ratepayers. Is that correct?
Yes, there's a cost anytime that the company procures new energy resources, whether it be renewable or otherwise.
And it is SPS position that in addition to the cost of those additional renewables to be acquired, SPS customers should also bear the cost of a financial incentive, correct?
Can you restate that or repeat that, please?
Yes. So it is SPS's position in this proceeding that in addition to the cost of additional renewables that customers will need to be acquiring on an accelerated basis in the future, SPS customers should also bear the cost of a financial incentive.
So we're asking for the commission to provide the incentive to exceed the minimum requirement of 20%. The cost on whether to bring on renewable resources will be there regardless of whether we're providing an incentive or not. So it's hard to you can't really incorporate the cost there. It's a matter of timing of when those renewable resources will need to be procured or purchased.
Sure. And you would agree if, and again, this is getting somewhat into Mr. Elsie's testimony, but as a general matter, if SPS's financial incentive proposal was approved, SPS will be needing to acquire new renewable resources in the, I believe it was the 2027 timeframe, around there.
Madam Hearing Examiner, I'm going to object as asked and answered. Mr. Rushoff has asked this questions multiple times.
Okay.
Mr. Rushoff?
I'll withdraw the question.
Very well. Go ahead, sir.
Mr. Contreras, it's SPS's position that customers should pay for a financial incentive in plan years 2022, 2023, and 2024 before they actually realize the benefits of additional renewables and decreased emissions. Is that correct?
It's my position that we're requesting the commission provide an incentive to SPS for exceeding our RPS minimum requirements.
And the incentive will be in plan years 2022, 2023, and 2024, correct?
That's correct.
And SPS's proposal to actually acquire additional renewable resources will be sometime in the future that's unknown at this point. Is that correct?
But can you repeat that, please?
Yes. So just to clarify, you just said that the financial incentive will apply to customers in 2022, 2023, and 2024. But you would agree with me that the benefits of producing and acquiring more renewables will be at some unknown point in the future. Is that correct?
Again, I'm going to object. Mr. Rushoff has asked this question multiple times already.
Okay. Mr. Contreras, I believe, just asked me to repeat the question, but
I let you repeat it and then I lodged my objection. It's been asked and answered.
Mr. Rushoff?
I would ask that it's my last question. If the witness would answer, just to clarify, then I think we've kind of been back and forth on this. So I just want to clarify this point and then we can be done.
Well, I think he has asked and answered it. So I'm going to sustain the objection. Mr. Rushoff, anything further?
Nope. Thank you. Those are all my questions.
Very well. Thank you. Ms. Coleman, Mr. McMillan, does Occidental have any questions for Mr. Contreras?
Yes, Your Honor. Michael McMillan for OPL. I have some questions for Mr. Contreras.
Go ahead, sir.
Morning, Mr. Contreras. So on page 8 of your direct testimony, you acknowledge that when administering the REA, the commission is required to prevent unreasonable impacts to customer electricity bills, right?
Yes, that's correct. That's on page 8, lines 8 and 9 specifically.
And on that same page, you acknowledge that the commission is required to do that while taking into consideration the economic and environmental costs and benefits of renewable energy resources and zero carbon resources. Is that right?
Yes, that's correct.
So in that same context, you talk about the reasonable cost threshold, and I want to talk a little bit about what that is. So the reasonable cost threshold is one of the ways that the commission ensures that customers are not unduly burdened by utilities' efforts to meet their RPS goals, right?
Yes, and that's specifically the standards laid out in the Renewable Energy Act.
And the reasonable cost threshold, that standard only applies in situations where the utility has not yet satisfied its RPS requirements. Is that right?
Can you repeat that, please?
Sure. The reasonable cost threshold standard, it only applies in situations where the utility has not yet met its RPS requirements. Is that correct?
I don't know that I specifically agree with that. Again, if I'm looking at the REA section 16.4E, that last sentence that I read earlier, that specifically talks about meeting and not being precluded from exceeding the standard.
Sure. Your Honor, could we pull up NMLCG 3, the copy of Rule 572, and specifically section 12C? Okay, Mr. I just lost it here, Your Honor. I think the screen share got shut off. Your Honor, could you share your screen? Oh, there we go. So, Mr. Contreras, if you could take a look at NMLCG 3 here, and let me see if I can find the sentence for us. Okay, it's in the middle of the paragraph, the sentence that begins when a public utility.
Yes, I see that.
Okay, could you read that sentence to yourself? And I wanted to ask you a question about it. Just let us know when you're done.
Okay, I'm done.
Now that sentence states that that if a utility can procure renewable energy resources at or below the reasonable cost threshold, it's required to do that to the extent necessary to meet the RPS standard. Is that right?
Yes, that's what it says.
And so that limits the application of the reasonable cost threshold to scenarios where a utility has not yet met its RPS goals. Is that right?
Again, I don't know that I necessarily agree with that because we are, as I mentioned in the REA, it does say that we should not be precluded from exceeding the requirement.
Fair enough, Mr. Contreras. I'll move on. So one of your criticisms of the RPS financial incentive rule is that it requires SPS to demonstrate that the benefits of its proposal, based on decreases to carbon and other emissions, right?
Yes.
And your proposed solution to that is not to decouple the benefits or the cost benefit analysis from reductions to carbon and other emissions. Is that right?
So our proposal is for variance from that section D.
Yeah, and your variance in particular is that you're hoping to eliminate the cost benefit analysis entirely. Is that right?
This specific cost benefit analysis, yes, as I described in my direct testimony and rebuttal testimony.
So in theory, SPS could have asked for a different variance where it just says, we'll go ahead and do a cost benefit analysis, but that cost benefit analysis won't be based on reductions to carbon emissions. Is that something SPS could have done in this case?
In theory, as you put it, yes. However, it's not certain how you would perform that cost benefit analysis as we've explained.
Okay, so under the variance that SPS did request, it's your position that the commission shouldn't consider the costs and benefits of the utility's proposal to exceed RPS goals before getting an incentive payment, right?
Sorry, can you repeat your question?
Yeah, so it is your position that the commission should not consider the costs and benefits of SPS's proposal to exceed its RPS goals before providing an incentive, right?
No, our position is that it should not consider Section D of the 572.22 financial incentive section of Rule 572. The commission has other avenues to consider our proposal, such as Section E. And as I mentioned, I believe the renewable cost threshold could also be used to consider the costs and benefits of our proposal.
Okay, so that gives me a little bit of clarity. It's not SPS's position that this decision should be entirely divorced from the costs and benefits of the proposal, correct?
It's specifically to Section D, it is.
So, Mr. Contreras, I don't really understand your position here. Is it SPS's position that the commission should find that the benefits of a proposal outweigh its costs before awarding a financial incentive?
So specifically, I'll just restate, our proposals or our request for variance is from Section D because this looks solely at the carbon emissions reduction. Our proposal, as I mentioned before, is solely on exceeding the public utilities annual RPS requirements as allowed in Section 572.22B1. And then looking at that, the commission can also look at Section E to judge whether our proposal is just and reasonable, or the RCT section, which we looked at earlier. Again, our variance request is partly because the Section D does not allow for a utility to look at just exceeding the public utilities annual RPS requirements with the retiring excess RECs as we have proposed.
So, Mr. Contreras, I don't think you really addressed my question there, which is, in your mind, should the commission conduct a cost-benefit analysis before awarding an RPS incentive?
I'm going to lodge an objection. I do think the witness has been asked this question and has answered it now twice.
No, I don't think he's answered it. I think he's answered around it. So I'm going to overrule the objection and ask you to answer the question, Mr. Contreras.
Again, I don't think the commission can look at specifically this cost benefit analysis on Section D. I believe the RCT is a form of a cost benefit analysis to look at when reviewing the incentive request here. And then again on Section E, that is another way to look at whether the costs outweigh or exceed the benefit of exceeding the RPS proposal.
Well, and to be clear, Mr. Contreras, you're referring to the the reasonable cost threshold. The reasonable cost threshold just says that it just is examining whether the cost of a renewable energy procurement is below $60 a megawatt hour, right?
Yes, that's what the definition of the RCT states in the REA.
Okay, so moving on a little bit. So SPS did conduct a cost benefit analysis and presented that in its application and testimony, right?
It did.
And it's very clear, and you admit that in this instance, the costs of SPS's proposal using SPS's methodology outweigh the benefits that SPS calculated, right?
That's what the analysis showed.
So I want to talk a little bit about the differential that SPS found there. So in SPS's initial analysis, and this is on page 42 of your direct testimony, Using SPS's methodology, y'all found that the costs of this proposal would be about $139.8 million, right?
Yes, that's what the testimony says.
And SPS calculated that the benefits of the proposal would be about $129 million, correct?
That's correct.
Will you agree with me that subject to check under SPS's analysis, the costs of SPS's proposal are about 8.4% greater than its benefits?
I don't know the specific percentage. I'd like to check that if I could, but I don't know this percentage.
But subject to check, can you agree that that looks about right?
I have a hard time of agreeing to a number I can't verify right now.
That's fine. I mean, we can all do math later. So let's move on. On pages 45 and 46 of your direct.
Hang on just a second. Ms. Lees, consider that a bench request. Mr. Contreras can calculate the approximate percentage as alleged in Mr. McMillan's question. Go ahead, Mr. McMillan.
Thank you, Your Honor. So on pages 45 and 46 of your direct, you state that there's currently a barrier to SPS qualifying for an incentive, right?
Where specifically are you looking at in my testimony?
Pages 45 and 46 of your direct testimony. It should be the last two lines of page 45 is where I'm starting.
Yes, I see that.
Okay, and so you say that there's currently a barrier to SPS qualifying for an incentive there, right?
Yes.
And you say that that's because right now the social cost of carbon is about equal to SPS's weighted levelized cost of generating renewable energy, right?
Yes.
So one of the inputs on the cost end of the cost benefit analysis that SPS did is that weighted levelized cost of generating renewable energy, correct?
I'm going to refer any questions about the cost to Mr. Elsey or the benefits to Ms. Lee. They are the ones that calculate our cost benefit analysis.
Okay, well, I can just address these questions with them then. And
but you put it in your testimony, Mr. Contreras. Why aren't you able to answer general questions about your own testimony?
So I gather information from Mr. Elsey and Ms. Lee, but they are the ones that can speak more specifically to these issues.
Go ahead, Mr. McMillan.
yeah, so Mr. Contreras, following on that, I think I'm going to stay at a pretty high level here. So if we get to something where I'm asking about a more specific part of this that you can't answer, please let me know. But I think we're going to stay within your general understanding here. So if you'll bear with me. So you would agree that one of the inputs to the cost end of the cost benefit analysis is SPS's weighted levelized cost of generating renewable energy, right?
Yes.
And that was determined by looking at SPS's entire renewable portfolio, both SPS owned resources and PPAs, right?
Again, I'd have to refer to Mr. Elsey on what he looked at for the analysis.
Okay, well, regardless, you can agree with me that all else equal, if SPS's levelized cost of generating renewable energy went down, that would decrease the costs of SPS's proposal, right?
I'm not sure that I can answer that. Mr. Elsey would be able to answer that.
Okay, I can address that with Mr. Elsey. And let's see if you can answer this one. So you'd agree with me that one of the inputs on the benefit side of SPS's analysis is the social cost of carbon, right?
I believe so. And again, as I mentioned earlier, Ms. Lee discusses the benefits.
Gotcha. And I can just address that with Ms. Lee. Okay, well, thank you, Mr. Contreras. That's all I have.
Very well. Ms. Lynch, any questions for Mr. Contreras?
No, ma'am.
Very well. And I don't believe I see a little box for Ms. Drake. So she must not be with us. So Mr. Bagatko, any questions for Mr. Contreras from staff?
At this point, barely, but I'll go ahead and ask him the question. Good morning, Mr. Contreras. How are you doing?
Good morning. I'm good, Mr. Baracco. How are you?
I'm all right. I'm not going to take up too much of your time because counsel before me has done a pretty good job of asking you questions on the same thing I wanted to talk about. So what I would do is very succinctly and directly, I hope, direct your attention to NMLCG Exhibit 3. And if you would assist me in bringing that up on the screen, Madam Hearing Examiner, I would appreciate it very much.
What section do you want, sir?
Would you please go to 17.9.572.22 on page 14 of NMLCG Exhibit 3.
Okay. Which section?
Right there. B. There we go. Thank you. Mr. Contreras, looking down there at section B, where it reads, and I'll quote, a financial or other incentive proposed under this section must be related to measures implemented by the utility after the effective date of this rule to accomplish at least one of the following purposes. And as we've discussed before, it's to exceed the public utilities annual RPS requirements or to reduce carbon dioxide emissions earlier than required by subsection A of 62.16.4. Did I read that more or less correctly, Mr. Contreras?
Yes.
When it talks about the effective date of the rule, do you know what that date is? And I would warrant for you that it's at the bottom of the rule. If you'd flip to it, Madam Hearing Examiner.
Yes, it was in May of 2021.
Thank you. There it is, 5/4/2021. Thank you for that. Mr. Contreras, if I've read your rebuttal correctly, you seem to have a specific idea of how to define the word measures as used in section B of the financial incentive rule. Is that fair to say?
Yes.
And is it also fair to say that your conception of the word measures as used in that section includes SPS's proposal to use the retirement of RECs to actuate the incentive in this case? Is that fair to say?
Yes.
Specifically, if you can tell me what in this rule or the companion statute would you base your definition of measures on for what you're requesting in this case? I hope that wasn't too clumsy of a question, but is there anything in the rule or the statute that you would point to support your definition of the word measures as used in section B of the financial incentive rule?
I think as I stated in my rebuttal testimony, there is no specific definition of the term measure. So I believe that there's a number of measures or actions, in other words, that you can take to exceed. However, the RA statute is very clear that to meet and exceed the RPS, you show that by retirement of the RECs.
Okay, well, that takes me to my next question. Madam Hearing Examiner, if you'd go back up to the top of the rule to paragraph A. Oops, it looks like, I'm sorry, you went past it. It would be on page 14 of this PDF document. Section A of the financial incentive rule.
Oh, the financial incentive section. Okay.
I'm sorry for not being clearer.
Put up.
All right, there we go. So, Mr. Contreras, do you see there in section A of the financial incentive rule where it basically says, well, I'll read it again. I'll read the rule. In accordance with subsection D of section 62.16.4 and MSA 1978, a public utility or any other person may apply by a motion or application requesting that the commission provide the public utility with the financial incentive or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standard set forth in 62.16.4. Did I read that portion of the rule correctly, Mr. Contreras?
Yes.
Well, are you taking the position that the retirement of RECs in and of itself results in the production or acquisition of renewable energy that exceeds the applicable RPS standards?
I think I've mentioned, or I've discussed this quite a bit with Mr. Rushoff. So the retirement of RECs exceeding, again, in accordance with B1, exceeding the annual RPS requirements will lead to encourage or will lead to SPS needing to produce or acquire renewable energy resources earlier than would otherwise be necessary.
Okay, and I think I recollect that. Thank you. And I'm sorry for being a little repetitive there. Well, let me sum it up this way then. If your definition of measures as used there in section B of the financial incentive rule is found not to include the retirement of RECs, SPS'S incentive request in this case is basically a non-starter then. Is that fair to say?
So as SPS'S, I think, made it clear in my direct testimony, our measure is to retire RECs in excess of the minimum requirement of the 20% for the years 22 through 24.
Correct. And if the retirement of RECs does not legally count as a quote unquote measure as used in section B there, then you're basically not eligible for the incentive mechanism that's touted by that section. Is that fair to say?
I think if we're not allowed to exceed the annual RPS requirements by retiring RECs, then that would be in conflict with section B1 of this rule.
All right, I thank you for that, and I definitely see, as I imagine a lot of other people, a significant briefing issue here. So I'll try not to beat this horse to death any more than I have, Madam Hearing Examiner, and that would be all I've got for Mr. Contreras. Thank you, Mr. Contreras.
Thank you.
Mr. Contreras, I guess the question I have on that particular answer to Mr. Bageko's question, you talk about a legal conflict, you talk about not being allowed to exceed. Whether or not you get a financial incentive wouldn't prohibit SPS from exceeding the RPS requirements, would it?
That's a correct statement, Your Honor. I should have been a little clear on that. We could, however, I'm very specific that we would not choose to exceed, and we would keep the bank reps for compliance purposes in later years if we're not granted the incentive.
Okay. Let's go off the record just a second. Melissa, are you ready for a 10-minute break?
I can go longer, or we can take a break. It's your pleasure. I'm fine.
Why don't we go ahead and take a break until I have it 10:21. Let's go ahead and take a break until 10:30, and we'll come back, and I've got a few questions for you, Mr. Contreras. And just to remind people, the YouTube's going to stay on, so you need to act accordingly, and so we'll be back at 10:30. Thank you. Okay. All right, I think we are coming back from our recess. And Mr. Contreras, were you able to do your calculation over the break?
Yes, ma'am, I did. And to confirm, that percentage was 8.41%, as I believe Mr. McMillan.
I'm sorry, please repeat it.
8.41%.
And that was the percentage that Mr. McMillan had asked you about?
Yes, specifically, it's on page 42, referring to the numbers on lines 11 and 13.
Very
My
well.
direct testimony.
Thank you.
You're welcome.
Okay, Mr. Contreras. Although the incentive request has gotten all the questions, your application did actually deal with a few other things, didn't it?
It did, yes, it did.
And you provide that testimony with the application, Mr. Contreras. And at pages 4 and 5 of your direct testimony, you actually include the other parts of your testimony with regard to the renewable application requirement, correct?
Yes, ma'am, that's correct.
And your required 2020 annual renewable RPS report, correct?
Yes, that's correct. That's attachment MAC2 to my direct testimony, and we concurrently filed that separately with the commission as well.
Very well. And then also, Mr. Contreras, you present SPS's proposed plan year and next plan year projected costs, along with SPS's requests for a reconciliation rate rider, a 2022 rate rider, and then the third rider, which would relate to the incentive, correct?
That's correct.
Further, you address in your testimony SPS's compliance with prior orders, don't you?
Yes, I do.
And you also provide testimony with regard as one of those prior orders, case number 18-00308 UT, you present information with regard to SPS's Solar Connect premium, correct?
And that's correct.
And if we can start, to clarify for the record, on page 7 of your direct testimony, SPS Exhibit 2, let's start at line 13. You're answering the question posed at lines 9 and 10. Does the REA consider the impact of the RPS requirements on utilities and their ability to plan and meet the requirements? And in answering that, at line 13, you say, first, the REA clearly recognizes both the importance of taking of market opportunities and the lumpiness of capacity additions by providing mandates that are minimums and that can be met no later than. That's your testimony, sir?
Yes, it is.
Will you define for the record, Mr. Contreras, a lumpiness of capacity additions?
Yeah, so what that is referring to is when you're adding capacity or adding new resources, you're not doing it in a straight line. You have to add a certain amount. So it's kind of you have a certain amount and it's a stair step to your next level of resources. And so it's not just constant. You can't just add, say we need, and again, for resource planning, Mr. Elsey could probably explain this in great detail, but you have to add a certain amount. You can't just do it more in a straight line type of addition. It's going to be more lumpy up and it's going from one perspective up to quite a bit higher one, not just a constant.
Sir, beginning on page 13 of your direct testimony, SPS Exhibit 2, continuing on through page 14, you are setting forth the renewable resources that SPS currently has to meet its plan year requirements, correct?
Yes, that's correct.
And I noticed, Mr. Contreras, that included in that testimony on page 14, lines 6 through 8, you testify that consistent with the commission's final order in case number 18-00201, SPS will apply the New Mexico energy allocation of the Sagamore and Hale wind facility RECs to its overall RPS compliance obligations. That's your testimony, sir?
Oh, yes, it is.
And case 18-00201 was SPS's 2017 RPS? No, it's 19. It's RPS for 2019. Is that correct?
Yeah, so it was our filing made in 2018 for plan year 2019.
Okay. And Mr. Contreras, there's been reference and previously to what we refer to as a CCN or certificate of convenience and necessity case for Hale and Sagamore. Do you recall those references this morning?
Yes, I do.
And did you testify in the CCN cases for Hale and Sagamore?
No, I did not.
Do you have some understanding of the proceedings for the CCNs for Hale and Sagamore?
I was not involved in that case. I do have some understanding of the ultimate stipulation that was approved by the commission in that case.
Well, just generally, Hale and Sagamore are both wind facilities, correct?
That is correct.
And Hale is in Texas and Sagamore is in New Mexico, correct?
Yes, sure.
And you've referred to a stipulation. So a stipulation was entered into among the parties in that case as to how the case should be ruled upon by the commission, correct?
That is correct.
And from what you're familiar with, whether it be in SPS's original application or the resulting stipulation, isn't it correct, Mr. Contreras, that SPS justified SPS justified its request for these two generating facilities, these two wind facilities, not on any type of renewable basis, but that these were justified as economic resources.
Generally speaking, I am aware that that's what our position was in that case in receiving the CCN for the Helen.
Sorry, in receiving the what? I'm sorry.
Receiving the CCN for both Helen Sagamore.
Okay, so then it's fair potentially to view SPS's position at the time it was trying to get approval for these two facilities. It wasn't looking at an eye toward anything to do with using RECs or meeting any standards, was it?
I can't say specifically whether it was or whether, as I mentioned, I wasn't actively involved in that. I do know, resulting from that case, that the issue of what to do with the RECs was deferred to the next applicable RPS case, which was a 2018, RPS case that was referenced on page 14.
Okay, so when you say deferred, from what are you saying was deferred from what case to what case?
So my understanding is that the case, the CCN case 20 or the 17-00044 case, did not address RECs, whether to sell or to retire or to use for RPS compliance purposes. That issue was addressed in the 18-00201-UT RPS case.
And are you saying that that issue of the RECs was specifically deferred by the commission in the CCN cases to the next renewable case? Or are you saying SPS chose to include that issue in case number 18-00201?
I cannot answer that one way or another. I just know that it was addressed in the 18-00201 case.
Well, your testimony is that something got deferred. So I specifically want to know what you meant by that.
So what I'm saying is that the issue of the RECs, whether to use them, sell them, use them for RPS compliance, was not addressed in the WIN CCN, the 2017 case. That was addressed in the 18-00201 RPS case.
And as a matter of fact, Mr. Contreras, no renewable issue was dealt with as it related to any type of RPS compliance in the CCN case, was it?
I don't believe so.
And your testimony, your direct testimony, SPS Exhibit 2, Mr. Contreras, on page 18, you're summarizing your attachment 3, appendix B, and you're saying at lines 16 through 20, and then on to page 19, lines 1 and 2, you're saying that the projected plan year renewable energy costs are 185,775,968 total company, and of that total, 74,653,835 are assigned to New Mexico retail customers, correct?
That's correct.
And 23 million of that, 23,508,580 will be recovered through the fuel clause.
So that number is actually a negative number. So it's essentially a credit to
Okay.
the fuel. If you look at that appendix B, column E, sorry, appendix B of attachment MAC3, column E, line 11, that shows a credit associated with the PTCs. So that's why you get a credit of the 23 million through the fuel.
And specifically, the PTC is the production tax credits from Hale and Sagamore.
Yes.
And so that's a negative 23,508,580, and which then at line 20, 82,636,346 will be recovered through base rates. Is that correct?
Yes, that's correct.
Along with 15,526,070 through the proposed 2022 RPS rider, correct?
That's correct.
And then your next group of testimony on page 19, you're asking about the next plan year costs. So presumably to 2023, and just comparing, it looks like those projected costs at lines total for New Mexico on line 7 of page 19 is $79,294,450.
That's correct.
So approximately a little over $5 million increase between the 2 years.
Yes.
And in your next plan year estimated cost, and then also in your plan year cost, did you include the incentive?
Not in these. Cost incentive is separate from these two.
Okay, so then if one wanted to get the total amount being charged to customers, they would have to add the total on line 18 of page 18 and line 7 on page 19 with what?
I'm sorry, can you, I'm lost on the numbers you're looking.
Okay, I'm just looking at the total retail amount to New Mexico customers on page 18, line 18.
And the 74.6 million. You're looking
Right.
at.
What are you going to add to that to get the total cost that SPS wants to collect from its ratepayers?
So the incentive amount, it is in my testimony. Let me get there and I can point directly to you where it's at. On page 33 of my direct testimony.
Okay.
Line 3.
Okay.
Says or starting on line 2, because SPS is requesting a $1 per rec incentive, this equates to a total incentive of $1,647,424 in plan year 22. and then $1,743,097 in fund year 23.
Okay. So I would need to add approximately $1.7 million.
But yes, if you're looking at the total for the plan
Okay.
2022, yes.
Okay. Thank you. And without for the record, Mr. Contreras, can you give us a high-level explanation of your testimony at pages 23 and 24 regarding that reconciliation process and why that occurred? Beginning at line 7 on page 23.
But yes, I'm looking at that. So we essentially, the 2020 RPS costs that we included in our 2019 filing, they are projected costs. And so we are reconciling the difference between what we were approved to collect and what actually occurred in the calendar year 2020.
Okay. And the difference, as you say in your testimony at line 16 and 17 of page 23, the difference was $1.3 million?
Yes, that's correct.
Okay, so that was a under collection, correct?
Yes, I believe so.
But then on page 24, when you look at that, you end up in an under collection of $3.5 million, right?
Yes, that's correct. And to look at that specific calculation, that is on attachment MAC2, Appendix E, page 1 of 1. That provides the detail of that breakdown.
I guess I'm just wondering about the magnitude of the under collection and the reasons for it.
Again, if we can turn to that Appendix E of MAC2 that I just referred to, column A, shows the total projected cost. Then column B are the actual costs. And then column C, and I'm going to correct something I mentioned earlier. The over/under collection is the difference between the actual cost and the revenue we actually receive from the RPS compliance. So you can see there on line 16, the actual costs were roughly $15.2 million. The revenue collected was roughly $11.7 million for that difference of about $3.5 million.
Is this typical of your of this particular rider?
Yes, it has happened, I believe, the last couple of years. I'd have to go back to look specifically at the attachment, but yes, I do believe it has occurred.
Is there anything that can be done to have better matching and not, or do you consider a $3.5 million under collection not to be that much of a big deal?
I don't know that I can say it is or is not a big deal. Again, our projected costs are based on forecasted actual costs are exactly what happened during the year, and then the revenue is just what we calculate. And I believe the reason for reconciling is to make up for this difference. And without actually having our prior case documentation or prior year reports in front of me, I can't tell you what the magnitude has been in prior years.
Okay. All right. Mr. Contreras, I know, or I seem to recall from last year's RPS case, case number 20-00143 was your 2021 renewable RPS case?
That case number sounds correct, yes.
Okay. It seems, if I recall correctly, we got rid of a lot of compliance issues with prior cases. Do you remember that?
Yes, and I actually discussed that in my direct testimony.
So it seems like there's only a few other cases that are left that are tied to a compliance requirement. Is that correct?
I believe so, yes.
I think you testify about prior commission compliance in pages 26 through 29 of your testimony.
Yes, that's correct.
And I guess it's time for my questions regarding the portion of your testimony. Well, let me just make clear for the record that in all of the reporting that you've done so far in your direct testimony, SPS is not requesting commission approval for any new renewable resources in this filing, is it?
No, it's not.
Okay. All right. So then we get to the part, section 8 of your testimony, where you're asking for the incentive. And I'd like to look at your testimony on page 33 of your direct SPS Exhibit 2 with the question posed at line 8 on page 33. Why has SPS proposed a financial incentive of $1 per rec? And you begin your answer at lines 9 and 10 with SPS believes that this amount reasonably incentivizes the early retirement of recs. And then you go on to say, as I explained below, it is below the cap required by Rule 572.22E, but is also commensurate with the price of the market price for recs in Texas, where there is an active market for recs. That's your testimony, sir?
Yes, it is.
And I'm going to go back and ask you if there's any other, well, the explanations in lines 10 and 12, is that the entirety of why you believe that this amount reasonably incentivizes the early retirement of rec, or are there other reasons?
I believe that's specifically referring to the dollar per rec amount, and I do believe that looking at the rec prices, the market price in recs in Texas, there's an article there that referenced the rec prices, and I even believe Mr. Pollock, this testimony referenced a $2.50 rec price for the calendar year 2021. It is very reasonable and is comparative to what we could have received had we had the opportunity to sell recs. And so yes, that is what I'm stating there.
And why do you believe what's happening in Texas is applicable to what's happening in New Mexico?
I don't know that it's necessarily applicable as much as looking at an active market of the cost of recs.
How do you define an active market?
Being able to sell and purchase the recs to other utilities or other companies for different compliance purposes.
Can you sell recs in New Mexico?
I don't know that.
Do you sell recs in New Mexico?
I can't answer that. I don't know.
Who can answer that question?
Mr. Elsey may be able to.
Ms. Lee's considered a bench request. I want to know if SPS is currently selling any recs in New Mexico. I'd also want to know what type of rec they are. And I don't want to get into anything confidential, but subject to the information not being confidential, I'd want to know how much per rec. Mr. Contreras, why not $2 a rec?
Well, $2 a rec would be above the cap. We could go up to, I believe, $1.95. I think that is SPS showing that we are not unreasonably asking for a dollar amount for the incentive. We wanted to show that although we could technically, according to our cap that we calculated, and it's shown on page 43 of my direct testimony, the cap for plan year 22 would be 3,207,620. So this goes back to, I believe, the commission looking at the incentive as just and reasonable, and showing that we are well below the cap that's calculated for our proposal.
Page 34 of your testimony, Mr. Contreras, you're talking about the incentive request with regard to the Renewable Energy Act and the rule, correct?
Yes.
The Rule 572 was recently amended as of May 4th of this year, correct?
That's correct.
And did SPS participate in that rulemaking proceeding?
Yes, we did.
And in fact, SPS has appealed to the New Mexico Supreme Court that particular rule, correct?
That's correct.
Were you involved, Mr. Contreras, in that rulemaking proceeding?
I was not directly involved. I was aware of what was occurring at the time, but I was not directly involved.
Did you help participate in SPS's comments that were filed in that rulemaking?
I reviewed SPS's comments.
And do you recall specifically commenting on the financial incentive section about the carbon emissions, the B2? Or section D?
I'm sure SPS did, but without being able to review the comments that were submitted, I can't say for sure one way or another.
So you don't recall specific comments on that section?
No, I do not recall any SPS's specific comments. I'd have to review SPS's comments to be able to answer that.
Okay. So your testimony, and I think earlier this morning, and then your testimony in SPS Exhibit 2, your direct testimony on page 35, lines 12 through 15, SPS will not retire excess RECs in order to exceed the current annual renewable portfolio standard, correct?
Absent an incentive, SPS will not retire those excess RECs.
Sir, on page 38 of your direct testimony, SPS Exhibit 2, you're answering the question posed at page 37. Please explain, that's line 16, please explain how SPS's proposal is consistent with Rule 572.22.c. And so you're answering that question. And then at line 6, 6 through 8, you say, Third, SPS cannot compare this proposed incentive with the magnitude of any other incentives that have been authorized by the commission, as it is not aware of any other incentives pursuant to the REA. That's your testimony, sir?
Yes, that.
So then SPS requesting this incentive is, you believe, a case of first impression with the commission. Is that correct?
I believe this is the first case since the passage of the rule that currently stands that there's been an incentive requested. So yes.
Or other than your, well, okay, so you're clarifying any incentive request since the passage of the new rule, correct?
That's correct.
But there were incentive requests prior to the new section of the rule, correct?
SPS requested an incentive, I believe, last year. However, I believe the hearing examiner, which I believe was you, recommended to move that, and that would be more appropriately addressed in a rulemaking, because at that point, the rule had not been developed regarding a financial incentive.
Right, and that was case number 20-00143, correct?
I believe so.
And that particular recommendation was approved by the commission, correct?
Yes, I believe so.
And the type of incentive that you asked for in your last RPS was not the same incentive that you're asking for now, correct?
No, it was not.
And are you aware of any other public utilities requesting and or receiving an incentive in a renewable case prior to the new part of the rule?
I do know SPS requested an incentive in 2015. I do not believe it was part of the RPS case. I don't know the case number offhand. I can get that to you if you'd like it. But we did request an incentive, but ultimately withdrew that request in that case.
Okay.
Other than SPS's 2015 request and the request last year, I am not aware of any other utility requesting an incentive in their RPS cases.
Okay. And my next question, I believe you answered, I think one of the very first questions that Mr. Rushoff asked you. Is it your testimony that SPS believes that the new section of the rule conflicts with the renewable energy statute?
Specifically, section D.
D as in David?
Yes, ma'am. And specifically, sorry, it's 572.22D. And that is the subject of the variance that we're requesting in this case.
Okay. And I also had a question, I think it was Mr. Rushoff, it could have been Mr. McMillan. Page 47 of your testimony, you're answering the questions posed at line 1 and 2. How would complying with these provisions of Rule 572 impact SPS and its customers if the variances are not granted? And you talk about at lines 3 through, well, actually lines 5 through 8, customers and all New Mexicans will not receive the benefits of the resulting increased renewable energy on SPS's system and decreased emissions, which section 62.16.4D seeks to incentivize. And that's correct, sir?
Yes, it is.
And I know you've been asked the question. I just want to try to put a time frame with this. And it may be one of the other witnesses that or your rebuttal. But my question is this: if the commission approves your incentive and you use those banked recs for the next 3 years, how does that affect the timing of the addition of new resources?
Mr. Elsey is a better witness to be able to explain, since he is our resource planning witness. He can explain when things are planned to go or forecast to go on with or without the incentive.
Okay, and I will ask him specifically, Mr. Contreras. I just wondered, as the manager of the rates, whether manager of the rate cases, whether you knew a ballpark number, if something like, oh, well, if we do this, then we're going to have to add, resources 5 years earlier or 4.
That, I believe it is, again, Mr. Elsey can explain this.
Okay. All right.
But I'll stop there.
Okay. And so now I'd like to look at SPS Exhibit 3, your rebuttal testimony. And I'm just going to make one general comment because I did not bring it up at the time SPS Exhibit 3 was admitted. I didn't see my note until now, or potentially part of your testimony would have been stricken. And I just want to note for the record that your testimony beginning on page 4 with the question, were there any requested approvals made by SPS that were either recommended for approval or not addressed by the direct testimonies of staff and interveners? And you go on lines 13 through 21 and lines 1 through 10 on page 5 to describe those requested approvals. And I would note for the record that pursuant to 1.2.2 dot 35, section N, which sets forth what is appropriate rebuttal testimony. Section 1 says rebuttal evidence is evidence which tends to explain, counteract, repel, or disprove evidence submitted by another party or staff. evidence which is merely cumulative or could have been more properly offered in the case in chief is not proper rebuttal evidence. Mr. Contreras, I'd like to look at page 6 of your testimony. You're answering the question posed at page 5. Do you have any general comments regarding the issues you address in this testimony? And on page 6, at lines 10 through 12, you say, refusing to award an incentive to SPS, comma, which is a statewide leader in renewable energy development, comma, would discourage SPS to strive to accelerate RPS compliance, comma, which the statute specifically encourages. That's your testimony, sir?
Yes, it is.
I'm finding that testimony a bit incredible, Mr. Contreras. With all of the investment, and especially the economic investment, and claims and that SPS has made with regard to Hale and Sagamore, as well as all of its other endeavors into the renewable resource industry. I'm finding it difficult to believe that if SPS doesn't get a couple of $1 million for the next 3 years in an incentive, that SPS is going to be discouraged to continue its business plan or its leadership role with regard to renewable energy.
Well, what this is specifically referring to is the RPS requirements. We are currently required to meet a standard of 20% of the utilities retail sales for New Mexico customers. So absent, as I mentioned before, absent an incentive, we will only retire regs at that 20% level. So we, without the incentive, we are not encouraged to retire regs up to that 40%, and we won't bring on for these purposes the renewable resources earlier, as we sit here today. So that's what that statement is referring to.
Well, don't you think that you might get a lot more than a couple $1 million a year in good press or goodwill from going ahead and doing that and being able to tout your efforts toward renewable resources?
I can't speak to press or goodwill. I just can speak to what we're asking for here. That is beyond my knowledge on what any resulting press or goodwill would be.
Okay, so you're not familiar with what SPS's overall business plan is for the future, or?
I am generally familiar with Xcel Energy's goals and SPS's plans, but I'm not specifically aware and can't speak to those specifically.
Okay. And let's go on to page 8 of your SPS Exhibit 3, your rebuttal testimony. And it's section A on page 8. You say SPS is requesting a financial incentive for an action that would not otherwise have occurred. And in this particular section of your testimony, you're filing rebuttal testimony because you have a difference of opinion with the staff witness, Ms. Leyba Tercero, on staff's position of what qualifies for an incentive, correct?
Yes.
And SPS, it's SPS's position that the proposed action of the retirement is what allows it to qualify under 22B, correct?
Yes, and specifically the retirement in excess of the 20% annual requirement for the RPS.
But I guess I'm trying to also distinguish page 9 of your rebuttal testimony, SPS Exhibit 3. At line 12, the question is posed, do any other interveners make similar arguments? And at line 13 and continuing through 15, you say OPL or Occidental's witness, Mr. Pollock, argues that SPS should not receive a financial incentive because the actions taken by SPS that have resulted in the utility having excess RECs predate not only Rule 572, but the effective date of the ETA, correct?
Yes.
But again, it's SPS's claim that the action is the retirement of the excess RECs over the 20% requirement.
That's correct.
So SPS doesn't believe that they have any obligation to actually generate or procure any brand new renewable energy after May 4th of 2021 in order to qualify for an incentive.
Not to purchase or to procure new energy, specifically looking at Rule 572.22 B1, the only requirement there is exceeding the annual RPS requirements, and I've stated before, the REA and the Rule 572 show that to meet and exceed, you have to show that by retiring RECs.
Does SPS believe that it has to generate new renewable energy after the new effective date of the rule to qualify for an incentive?
So the consequence of retiring these RECs early will require SPS to purchase. SPS is generating, and you can see on MAC 3, Appendix A, page 1, what our annual generation in terms of RECs is going to be for the year 2022. However, as I testified earlier, and as note 1 shows, SPS's general policy is to retire a REC on the first in and first out basis. So therefore, SPS retires the older RECs first. The REA allows RECs to be banked up to 4 years specifically. And so the practice of SPS, and Mr. Elsie can get into this in more detail, we have, as I mentioned, we practice a first in, first out in retirement of RECs.
So, Mr. Contreras, if you could help me clarify and understand a little bit better your testimony on page 15 of SPS Exhibit 3, a rebuttal testimony. And you're answering the question posed on lines 14 or page 14, lines 3 through 8. Ms. Labor-Trussero testifies that if the commission disagrees with staff's interpretation of its recently amended Rule 572, staff recommends that any incentive that SPS may receive for the retirement of RECs associated with SPS's Hale and Sagamore wind projects be factored into the evaluation of the net benefits as required by the stipulation in case number 17-00044. Do you agree with this argument, which you don't? And you claim that any costs and benefits appear to be outside of the scope of the case. And on page 15, you say, SPS is forbidden by statute, however, from selling the New Mexico allocated portion of the Hale and Sagamore generated RECs. Correct?
That's correct.
Then I'm confused. Why was there a section included in the stipulation that you reference on page 15 of SPS Exhibit 3 that defines the REC component? and actually says, if the commission concludes in the future that SPS should not sell the New Mexico retail customer share of excess hail and Sagamore Rex, then the component would drop out of the net cost calculation. So if you're saying they're that SPS is forbidden from doing that, then why was it included in the stipulation?
It's an issue of the timing of when the CCN was approved versus when the Energy Transition Act, ETA, made changes to the REA, specifically when in 2017, the 17-00044 case, which was the WIN CCN, at that time, SPS could sell had the commission granted SPS the ability to sell, which the commission did do, I believe, in the 2018 RPS case that we referred earlier. However, after the passage of the ETA, that's when this new statement that I quote on lines 11 through 15, and I corrected the reference to 62.16.5B2. Specifically, would like to point out that unless the certificates start on line 12, unless the certificates are from a rate-based public utility plant, in which case the entirety of the renewable energy certificates from that plant shall be retired by the utility on behalf of itself or its customers. And both Hell and Sagamore are a rate-based utility plant.
And is SPS in any danger of having expired RECs?
I don't know that answer. Mr. Elsey may know the answer to that question.
So you're saying that that's not a particular basis then for SPS to make this specific incentive proposal?
No, not specifically.
Is there any potential negative financial repercussion to SPS from having, or its ratepayers, from having an expired REC?
Other than if RECs expire without retiring them for compliance purposes, we may have to go and purchase new RECs that we would have otherwise been able to utilize.
But as you claim on page 25 of your rebuttal testimony, just because it expired doesn't mean that potentially you can't still collect any cost that might be from a result of the expiration, correct?
Yes, that's my understanding of on line 7, start on line 7 through 9, quoting the REA, the commission shall not disallow the recovery of the cost associated with any expired renewable energy certificates. And that reference is 62.14.5B2. Actually, I will correct that reference. That should be 62.16.5B2.
And sir, on SPS 3, page 31, you are referencing Mr. Pollock's testimony about it's not a good policy to award a financial incentive absent the analysis required by Rule 22D because the regulatory compact provides enough of an incentive for utilities to pursue investments that comply with the REA, and that the incentive SPS seeks is already above and beyond the incentive provided. Do you agree? And you're saying, no, you don't. And then what I'd like to know about is beginning at line 16, continuing on page 32 through line 2, you say section 62.16.4D contains no requirement that in order to earn an incentive, a utility must demonstrate that the cost of the measure taken to further the goals set forth in the REA be lower than the benefits that the measure will achieve. So that's your testimony, sir?
That's correct.
So SPS really believes that renewables at any cost, that they're going to be allowed to recover those?
No, that's contrary to that. I don't believe that renewables at any cost. As I mentioned earlier, the commission has section 22E, which is a cap on the incentive. You also have the RCT, the renewable cost threshold, that puts a dollar threshold on being able to procure, and that's at a $60 per megawatt hour. And so, no, I don't believe in, to your question earlier on why we picked $1 per rec, where arguably we could have chosen to go with the cap at $3.2 million, but we did not because of what we're talking about here.
Mr. Contreras, do you have renewable requirements in Texas?
Not to the extent we do in New Mexico.
But do you have any?
I believe there may be some. I'm not aware of the specifics of anything.
Okay. Thank you, sir. I appreciate it. That's all the questions that I had for you. Ms. Lees, any redirect of your witness?
No redirect, Your Honor.
Okay. We'll go back through. Any questions, Mr. Rushoff, on mine?
No further questions here.
No recross.
No.
What about you, Mr. McMillan?
No recross, Your Honor.
Very well. Let's see, Ms. Lynch didn't have any. Ms. Drake was not here. Mr. Bagatko?
Madam Hearing Examiner, no thank you, no recross necessary.
Very well. Subject to the one bench request, you are excused. Mr. Contreras, thank you very much.
Thank you, Your Honor.
Okay. Ms. Lees, you have another witness.
We do, Your Honor. The next witness SPS would like to present is Mr. Elsey.
Okay.
He may be in the waiting room.
room. Okay. Says he's connecting. Maybe. Well, I don't know. Maybe he needs to go back out and come back in because it still says he's connecting to the audio. Oh, nope. There you are, Mr. Elsey. You want to unmute yourself?
We're still muted, Ben.
There you go. Hello there.
Good morning. Good morning. How are you?
I'm fine. Miss Lees, you have another witness.
I do. This is Mr. Ben Elsey. Let's go ahead and get him sworn in.
Okay. Melissa, would you please swear in Mr. Elsey?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you very much. Go ahead, Miss Lees.
Thank you. Good morning, Mr. Elsey. Can you please state your name, your full name for the record?
Yes, it's Ben Ronald Elsey.
And do you have a document in front of you that has been labeled SPS Exhibit 4?
I do.
Can you identify that document for the record?
Yes, this is my direct testimony from this case.
Okay. And do you have any corrections to make to this document?
I do not.
And if I were to ask you the same questions today as are contained in this document, would your answers be the same?
They would.
And are those answers true and correct to the best of your knowledge?
They are.
And the 6 attachments to this document, were those created by you or under your direct supervision and control?
They were.
With that, Madam Hearing Examiner, SPS moves Exhibit 4 into the record.
Any objection to what's been identified as Mr. Elsey's direct testimony as verified by him here today? Hearing or seeing no objection, SPS 4 is admitted. Ms. Lees?
With that, Your Honor, SPS passes this witness for cross-examination.
Very well. Any questions by the New Mexico Large Customer Group?
Yes, just a couple, Your Honor.
Go ahead, Mr. Rushoff.
Okay. Good morning, Mr. Elsey. My name is Austin Rushoff. I'm counsel for the New Mexico Large Customer Group in this proceeding. I would like to good morning. I'd like to direct you to page 8 of your direct testimony, if you have that in front of you.
Okay, I am there.
And the question there on page 8, you discuss SPS presenting its compliance projections using both a financial load forecast and a planning load forecast. Is that correct?
That's correct.
And can you just briefly explain the difference between those two forecasts?
Sure. The financial load forecast is a fairly conservative forecast. It includes minimal oil and gas growth in the foreseeable future. The financial forecast is primarily used for financial reasons, budgeting, financial reporting. The planning forecast includes some more oil and gas growth, which we think is probably likely, but not certain.
Okay. Moving to page 9, the next page of your direct testimony. You state that using a financial load forecast and relying on banked recs, SPS is projecting RPS compliance beyond 2031. Is that correct?
That is correct.
And then using the planning load forecast and again relying on banked recs, SPS is projecting compliance through 2030, correct?
That is correct.
And just again to clarify, both of those projections are based on a scenario where SPS does not accelerate retirement of recs as it is proposed in this proceeding.
That is correct.
Okay. And I wanted to look, just moving to page 11 of your testimony, and I just have a couple questions about the proposal to accelerate banked recs. Looks like on page 11 there, I'm looking at lines 3 through 6. And just to confirm, if SPS's proposal to accelerate retirement of recs was approved, SPS is projecting compliance with the RPS through, looks like 2026 and 2029, depending on the type of forecast used. Is that correct?
It is.
Okay. And if SPS's proposal is approved, proposal for a financial incentive is approved, SPS will be required to accelerate the acquisition of additional renewable resources to maintain RPS compliance at some point in the future. Is that correct?
That is correct.
And
When would that point be, Mr. Elsey?
Using the planning financial load forecast, we would need new resources by 2027. And using the financial load forecast, we would need new resources by 2030. 30.
And do you find, if you can quantify, do you find one of your proposed forecasts to be more realistic or accurate than the other?
From a planning perspective, I would lean towards the planning load forecast. In truth, the likely event is somewhere in between the two.
And is that actually how, in your position, that you sort of view these things, as you take both pieces of information and then sort of, blend the results together?
Again, I lean more towards the planning load forecast than the financial load forecast, but of course it is a good check to confirm with both types of load forecast.
And how accurate do you think your financial load forecast potentially is, if we looked at it in the current, using current information as of today?
Could you perhaps rephrase that question, please?
I can. I've been reading things recently on skyrocketing costs, especially like gas costs. Where I think in the local newspaper they're projecting like 185% increase or something for the winter heating load, and that the natural gas prices are really starting to go up. And I just wondered, if you use that kind of information as opposed to, when you submitted your testimony for 3 or 4 months ago, whether or not anything has changed.
We have, since I filed my testimony, released a new load forecast in the last 2 or 3 weeks. I did check before this hearing. There isn't a significant change in our load forecast over the periods we are looking at.
Okay, there is no significant change.
Correct.
Okay, thank you, sir. Go ahead, Mr. Rushoff.
thank you. And those questions were helpful. Mr. Elsey, the financial forecasts that you've provided here, the forecast you've provided, both the planning and financial forecast, those include a number of assumptions. Is that correct?
That is correct.
And would load growth, I assume, is one of those assumptions that's built into those forecasts?
Load growth is probably the biggest driver between the two forecasts. That is correct.
Okay. And would you agree that if customers increase the amount of customer-sited generation at their facilities, that would impact SPS's projections, correct?
That is correct.
Okay. And just to confirm, I've talked to Mr. Contreras about this some, but the acquisition of potential future renewable resources is not specifically included in this proceeding. Is that correct?
That is correct. We are not proposing any new resources in this proceeding.
Okay. And Mr. Elsey, would you agree that if SPS acquired additional renewable resources on an accelerated basis, SPS customers would also have to pay for such renewable resources on an accelerated basis?
It would depend on your definition of pay for or cost. And if I could maybe elaborate on that, there would obviously be a direct course of cost of paying for new resources, the cost of new energy. However, if those resources were to generate energy savings, that would offset those costs. So potentially a customer could see savings for new resources and not additional costs.
Understood. Thank you, Mr. Elsey. Those are all of my questions today.
Thank you.
Thank you. Mr. McMillan, Ms. Coleman, any questions for Mr. Elsey?
Yes, Your Honor. I have just a few minutes worth of questions.
Go ahead, sir.
Good morning, Mr. Elsey. So one of the inputs to the cost end of the cost benefit analysis that the SPS did was the weighted levelized cost of generating renewable energy, right?
I'm sorry, I'm not hearing that.
You're breaking up there, Mr. McMillan.
Okay, let me try again here. Can you hear me now?
Yes.
Okay. Mr. Elsey, one of the inputs to the cost end of SPS's cost benefit analysis was the weighted levelized cost of generating renewable energy, right?
That is correct.
And you show that number on your exhibit BRE-6, correct?
Yes, I do.
And that cost is determined by looking at SPS's entire renewable portfolio, right?
It is determined by looking at our renewable portfolio that produce RECs that are counted towards the New Mexico RPS.
Okay. And so looking at BRE-6, some of the older PPAs that are listed on there have pretty high costs on a per megawatt hour basis, correct?
Relatively speaking, compared to renewable costs today, yes, there are a couple of examples where they are significantly higher.
So for example, the Sun Edison PPAs are at over $130 a megawatt hour, correct?
Yes, that is correct.
So as those higher cost PPAs expire, it's likely that SPS's levelized cost of generating renewable energy would go down, right?
To some extent, I agree with that. I would point out the Sun Edison PPA, for example, is relatively small in terms of its generation compared to some of our newer resources. So it wouldn't have a direct average impact.
Gotcha. So similarly, as SPS adds new PPAs, if those have lower than average costs, that would also drive the levelized cost down, right?
If they have lower than the average, then yes.
So for example, the Bonita 1 and Bonita 2 PPAs are at about $23 a megawatt hour, and those come online in 2024, right?
The projects themselves actually came online in 2019, I believe, but we cannot purchase the RECs until 2024.
Gotcha. So when you start purchasing the RECs, that will be at below your then average cost of generating renewable energy, right?
That is correct. I think if you look in on BRE Exhibit 6 there, in 2023, our average cost is $26.82. And the Bonita PPAs do bring that average down ever so slightly to $26.40.
Gotcha. So I actually want to look at exactly that line on that chart, the weighted average cost, the bottom line number. So in 2022, the projected weighted average cost is $27.08, right?
Yes, it is.
And then by 2024, that's dropped to $26.40, correct?
Could you just repeat the year again, please?
Oh, yes. And then by 2024, that number has dropped to $26.40, correct?
Yes, it has.
Okay, so subject to check, much like with Mr. Contreras earlier, would you agree with me that the weighted average cost of generating renewable energy will decrease by about 2.5% between 2022 and 2024?
Again, I would have to check the numbers. I would say that looks in the ballpark without checking.
Okay. And all else equal in the cost benefit calculations that you performed, decreasing SPS's levelized cost of generating renewable energy, that would drive the cost of SPS's proposal down, right?
Could you perhaps reword that question?
Yeah, sure. If SPS's cost of generating renewable energy goes down, holding all other factors equal in the cost analysis you did, the cost of SPS's proposal would go down. Is that right?
If you allow me to, I'm just going to slightly rephrase that and make sure I understand the question. You're asking if we bring on new resources that are lower cost than the average, it would drive the average down. Is that correct?
No, I'm asking in the calculations that you did where you calculated the cost of SPS's proposal to retire RECs early. In that calculation, if you hold all factors equal, except the levelized cost of generating renewable energy, that would decrease the cost of SPS's proposal to retire RECs. Is that right?
I'm still not, sorry, I apologize. I'm not sure I'm following the question. Mm-hmm. All else being equal, you reduce the LCOE of individual projects, it would reduce our average cost?
No, so I'm referring to the calculations that SPS performed to determine the cost of the proposal here, the incentive proposal to retire RECs. So that's the question or the analysis that resulted in a bottom line number that I was talking with Mr. Contreras about what is $139.8 million. Do you know what I'm talking about?
I see the line, yes.
Okay, so that calculation, if all you do is substitute the weighted average cost of generating renewable energy number that you use with a lower number, that would decrease the bottom line cost of SPS's incentive proposal, right?
Yes, it would.
Okay, that's all I have. Thank you, Mr. Elsey.
Mr. Elsey, do you know when those Sun Edison PPA expires?
I do not know off the top of my head. I believe they were 20-year PPAs and they were in service in the early 2010 to 2012 range. So subject to check, probably another decade or less from now.
Okay. Thank you, sir. Ms. Lynch, any questions for Mr. Elsey?
No, thank you.
Okay. I don't see Ms. Drake. Mr. Bagatko, questions for Mr. Elsey?
Madam Hearing Examiner, no questions for Mr. Elsey, but thank you.
Okay, and I believe I've asked. Let me just go through one more time. Well, Mr. Elsey, to the extent you indicated that you had just redone the financial analysis and that no significant changes for the years that you were looking at. Is that correct?
That is correct. And
Okay.
just to clarify, Madam Hearing Examiner, I didn't actually update the load forecast. We have a separate group within Excel Energy who conducts that analysis.
Okay. So in addition to, do you agree that generally within your knowledge of the gas price market that that costs are increasing for natural gas?
Yes, I agree that there has been a recent substantial cost in natural gas prices. I would like to clarify that that doesn't directly drive demand, that drives cost of our generation fleet.
Okay. And then also, it seems that recently there's been a lot of press about supply problems, and pretty much in getting most any kind of commodity that one might need. Has that been figured into any financial analysis?
In the financial analyses I have conducted in this case, all of these resources are existing, so supply chain impacts would not impact the costs.
Okay. Thank you, sir. Ms. Lees,
Thank you very much.
any redirect for your witness?
I have no redirect, Your Honor.
Very well. Any recross by any Mr. Rushoff or Mr. McMillan?
No.
No, Your Honor.
No. Very well. Thank you. Subject to a bench request of Mr. Elsey calculating the decrease that was proposed in the question of approximately, I think, 2.5%, which you can report after your witness calculates it, Ms. Lees. He does not have to come back. Yeah, I think the question and the claim was that 2.5% decrease between 2022 and 2024. Subject to that, you're excused, Mr. Elsey. Thank you very much.
Thank you very much.
Okay, we are past the noon hour, and I suggest that at this point, we take an hour and we come back. The computer says 12:10. I suggest we come back at 1:10 after our lunch and recess, and we'll resume then with the evidentiary portion of our hearing. Okay, very well. We are recessed then until 1:10. Thank you.
Madam Hearing Examiner, you have
Yes,
another outstanding bench request on whether SPS sells RECs in New Mexico.
You can answer that one when we come back.
Okay, could I just get clarification? When you say what type of REC, are you saying what type of resource generated that REC?
I am.
Okay.
I am, and not being as concise as I should have been.
No,
So
I just
yes.
wanted to clarify. And you're fine with me answering that bench request. I don't need to call Mr. Contreras back, or do you want me to
No,
call him
you just attribute where you got the information.
back? Okay, thank you.
Okay. Thank you. All right, we're recessed for an hour. Thank you. Hi, how are you?
I'm just fine. How are you?
I'm okay. How was lunch?
It was great.
Awesome.
Yes. Love lunchtime.
So are things going okay as far as communication, your audio?
Yes, my audio is very, very good. The only thing I'd ask if people could just clearly say D and B. I just want to make sure I hear it right.
I'm having trouble with that too.
Yeah. I mean, I can go and look at the rule and hope those match up, but it's better if I just get it right. So I don't know if it makes sense to say D is in dog the first time, not when they, you know what I mean, or something, or B is in boy the first time. I just want to make sure.
Okay.
And since they're wanting it a quick turnaround, I don't want to spend time trying to find that. If I just hear it, it's better.
Okay.
And that would be the only thing. I think those are just the bugaboos.
Awesome.
Yeah.
Good. Well, it looks like we've got some people that want to come in the room. Now, did you see I sent you an email?
Oh, no, I didn't even check my email.
Uh,
I can look really quick. Let's see. I haven't looked at my email all day, so let's hope I can find it fast.
Oh, I was just letting you know that
Oh,
I was sticking to my projection.
oh, good. Yeah, I just see it now.
Okay.
Yeah.
And then when you think, wait a minute.
Yeah, isn't it? Yeah, that's good. I
Okay.
can see that the other ones are fast and, they take what they take. So whatever you need.
Right. Awesome. Okay. Well, let's
Oh, give me one sec.
get that off there. Okay. Hey, Miss Lees, what do you see on your screen for me?
SPS's 2019 RPS report.
Okay. This is really cool. I guess I can. Now, what do you see?
I think that is the rule. Yeah, 572.
Yeah, so I can have like multiple things open at the same time and then just flip back and forth on the screen share.
Very cool.
Well, what can I say? It doesn't take much, for me to get happy.
It's the little things.
It is the little things. Yeah, I mean, screen sharing in a hearing is a little daunting at first.
It's working out today.
I think it has. I think I got a lot of practice in the SPS rate case when I kept going back and forth to those same exhibits over and over. So I think that was excellent practice for me.
Happy to provide the opportunity.
Well, good. That's very good. Okay, it says, okay, I'm sharing my screen. All right, what about participants? I don't see any more waiting. Okay. All right, let's make sure we have everyone. The only one I do not see is Ms. Lynch. Okay, well, we'll wait a couple of minutes. Are we going to have anything procedural that we need to deal with before we go back on the record?
Nothing that I'm aware of.
Okay.
From SPS's, for SPS's part.
Okay. Hello there, Ms. Drake. We've completed 2 witnesses.
Great. Thank you, ma'am.
And okay, well, we'll go ahead and if we can go back on the record, please. We are returning from our lunch recess. And I believe, Ms. Lees, you have another witness.
I do, Your Honor, but before I call Ms. Lieb to the stand, I do have responses to the 2 outstanding bench requests that you had. Would you like me to address that now?
Absolutely, go right ahead.
I'm going to go in reverse order. The first one I'll address is you asked Mr. Elsey to confirm the percentage difference on his attachment 6, BRE 6, between the weighted average cost for 2022 and the weighted average cost for 2024. And he did confirm that's 2.5% difference.
Okay, a 2.5% decrease. Is that correct?
Yeah, that's correct.
Okay, very well.
The weighted average cost does decrease.
Okay.
And then the next bench request I'm going to respond to is you asked, does SPS sell RECs in New Mexico? SPS hasn't sold any RECs in New Mexico since the passage of the ETA, and SPS does not currently market or sell RECs in New Mexico. As a practical matter, SPS doesn't believe it can sell RECs in New Mexico because of the requirement in the ETA to pair RECs with energy.
As testified to by Mr. Contreras.
Correct.
Okay, very well, thank you. Anything further on those?
No.
Okay, and let me, before you call your witness, let me just address just for clarification purposes, you should see on your screen page 5 of the application. And in line 6, that is the wrong case number.
I'm on page 5 and hold on.
I said line 6, item 6. The top of the page, if you look at my share screen.
Okay.
Am I sharing?
Oh, did we transpose the 3 and the 4?
You did.
Okay.
So for clarification purposes, Ms. Lees, last year's RPS case was 20-00143-UT.
Yes, it was. Thank
Okay.
you, Madam Hearing Examiner.
Well, like I say, just get that case number in there. And then also for the record, let me go ahead at this time and just for clarification purposes, indicate to the record that I asked Mr. Contreras whether or not the Rule 572, the latest iteration had been appealed, and the answer was yes. And just for record purposes, the rulemaking for that change in the rule was 20-00296-UT. And then one final thing that in speaking with our court reporter, Ms. Gonzalez, so that our transcript is clear, we have been speaking a lot earlier this morning with reference to sections B as in bay and D as in dog. And just so our record, since we're zooming, if when you're referring to section B or D, indicate by a word, that would be good. Again, just one more reminder, We're on YouTube. So just remember, that's what's going on. And I believe that we're ready now, unless we have anything further procedural wise or clarification wise. Ms. Lees, you have another witness. Excuse me.
Thank you, Madam Hearing Examiner. SPS calls Sydney Lieb to the stand to testify.
And good afternoon, Ms. Lieb. I noticed that you have a doctorate.
I do.
And it's always been my preference that that we show respect for that educational attainment. And I've always referred to PhD witnesses as doctor. Do you prefer that?
Yes, that would be great. Thank you.
Thank you. Go ahead, Ms. Lees.
May we please have Dr. Lieb sworn in?
Yes. Ms. Gonzalez, would you please swear in Dr. Lieb?
Please raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Dr. Lieb. Can you please state your name for the record?
Sydney Marie Lieb.
Thank you. And I have placed before you SPS Exhibit 5. Can you please identify that document?
That document is the direct testimony that I filed in this case on behalf of SPS.
Okay. And if I asked you the questions contained in this document today, would your answers be the same?
Yes.
And are those answers true and correct to the best of your knowledge?
Yes.
And you do not have any attachments to this testimony, correct?
That's correct.
Okay. The next document that you should have in front of you is marked as SPS Exhibit 6. Can you please identify that document for the record?
That document is my rebuttal testimony.
Okay. And that document does not have any attachments as well, correct?
Correct.
If I were to ask you the same questions contained in this document today, would your answers be the same?
Yes.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Madam Hearing Examiner, SPS moves Exhibit 5 and Exhibit 6 into the record.
Any objection as to what has been identified and verified by Dr. Lieb as SPS Exhibit 4, her direct testimony?
Madam Hearing Examiner, I'm just going to correct that it is SPS Exhibit 5 that is
5.
Dr.
Yep.
Lieb's direct testimony.
Yes, thank you. Exhibit 5. Hearing no objections, SPS Exhibit 5 is admitted. Is there any objection to what has been identified and verified by Dr. Lieb as her rebuttal testimony, SPS Exhibit 6? Hearing no objection, SPS Exhibit 6 is admitted. Ms. Lees?
SPS passes this witness on for cross-examination. Thank you.
Thank you. Any questions from the New Mexico Large Customer Group?
No questions for Dr. Lieb, Your Honor.
Very well. Thanks, Mr. Rushoff. Any questions from Occidental? Mr. McMillan.
A few questions, Your Honor.
Go ahead, sir.
Good afternoon, Dr. Lieb. So one of the inputs to the benefit side of SPS's cost benefit analysis was the social cost of carbon, right?
That's correct.
And in the calculation that you performed, if you hold everything else equal and increase the social cost of carbon, that would increase the benefits of SPS's proposal, right?
Yes.
On page 10 of your direct testimony, you discuss the metric that you use for the social cost of carbon, right?
Yes, at the bottom of page 10 is where we discuss the metric.
And right there at the bottom of page 10, you say that the the metric that you used is expected to increase from $52 a metric ton in 2022 to $54 a metric ton in 2024, correct?
Yes.
So subject to check, would you agree with me that that represents about a 3.8% increase in the social cost of carbon over that 2-year period?
I'm not going to do any performance math, but subject to a check, I could agree with that escalation rate.
Thank you, Dr. Lee. Your Honor, that's all the questions I have.
Ms. Lees, could you have Dr. Lee do that calculation and you can report just so that, you know, we don't have to have people guessing on the increase there?
Yes,
Also,
Your Honor.
Since we're on that page, before we go any further, Dr. Lieb, if you want to look at page 9 or look at line 9 of that testimony on page 10.
Sure.
Do you want to correct damages?
We could correct the spelling of the word damages, yes.
Okay, thank you. Want to make sure it's not some word I didn't know what it was. Okay, very well. Any questions, Ms. Lynch from CCAE?
No, thank you, hearing examiner.
Okay. What about from you, Ms. Drake?
No questions. Thank you.
Thank you. And Mr. Bagatko, any questions from staff?
Madam Hearing Examiner, no questions for Dr. Lieb today, but thank you.
And I just have a few. Dr. Lieben, looking at your qualifications and background, I think as I previously, in making sure that I was addressing you correctly, I see that you have a doctorate of philosophy in mechanical engineering. Is that correct?
That's correct.
Well, as a pitiful minor in undergraduate of philosophy, and having dealt with many mechanical engineers, how do those two things correspond with each other?
So the funny thing about getting a doctorate in engineering is that at some point it becomes pure science. And in my lab group, where my doctorate was paid for largely out of my advisor's research funds, we were all required to take quantum chemistry at the graduate level because it would teach us more about the function of the world. And I think that as you start to approach science in its purest form, it becomes much closer to philosophy than applications of rules and numbers, and more about the elegance in which things function in the world on a daily basis.
Interesting. And it probably is more marketable to have a doctorate of philosophy in mechanical engineering than a doctorate of philosophy?
It might depend on the market that you're approaching.
Very well. At one particular point in time, I thought about changing my major to philosophy. And my father asked me how I was going to be able to make a living at that. And I couldn't come up with an answer, so I didn't end up changing my major. But I'm glad to know that there is some kind of convergence or at least connection between the pure science and the applied sciences. And I think, Doctor, I think I understand your testimony. And I know in your calculation, and the reference of your testimony, beginning on page 6, you're answering the question posed at lines 1 and 2. Please describe the requirements a utility must demonstrate under Rule 572.22 to receive the financial incentive. And as we know, Section 1 of the rule talks about the utility's total carbon dioxide emission. But in your calculation, you include, as indicated on page 9, you include other emissions, correct?
That's correct.
Do you have an explanation why that you think that the commission only included the carbon dioxide emissions in the rule?
I don't feel that I can answer why the commission chose only to include the carbon dioxide emissions. No.
In your knowledge and of other states' rules or other rules that try to quantify emissions, do they usually just include carbon dioxide or do they include others?
Other rules that are focused on carbon emissions inventories, for example, the California cap and trade rule, or if you look at the mandatory reporting rule at the federal level, which is not a compliance obligation, but just a reporting obligation, will include methane and nitrous oxide on a carbon equivalent basis in total carbon emission inventories.
Okay. Dr. Lee, your testimony on page 8, you are answering the question posed at line 7 through 9. What is the reduction in SPS's emissions attributable to retiring RECs in order to meet the 40% renewable portfolio standard 3 years early? When your answer, lines 10 through 14, you refer to total reduction in SPS's CO2 emissions attributable to SPS's proposal is 2.61 million short tons. That's your testimony?
That is my testimony.
What is a short ton?
So tons there's metric tons, and then short tons are the English unit equivalent. It's 2,000 pounds.
Okay.
Unfortunately, both systems chose to use the word tons, so we have to clarify which one we're talking about.
Okay. On page 11 of your testimony, Dr. Lee, you're answering the question posed at line 1. Why has SPS chosen to use the capital S, capital C dash, capital G, capital H, capital G to place a value on emissions? And you've defined that on page 9 as the social cost of greenhouse gases, correct?
That's correct.
Okay. And so you're answering the question on page 11, why SPS has chosen to use that to place a value on emissions. And at lines 7 through 10, you say the social cost of carbon is within a few dollars of the standardized price for carbon emissions that electric utilities are required to use when filing their integrated resource plan, correct?
Yes.
What is the significance of that comparison to you?
The significance of the comparison is that in this analysis, we chose to use the federal social cost of carbon, because it's well documented and publicly available and used in a lot of jurisdictions across the country. And we wanted to draw a comparison between what's being used in integrated resource planning, specifically in the state of New Mexico, and indicate that the values are not materially different. They're very similar.
Okay. And then, Dr. Leap, on your page 12 of your testimony, the question posed at line 7 and 8, what is the estimated value of the reduction in carbon dioxide emissions attributable to SPS's proposal? You begin your answer at line 9, and you say the estimated value of the reduction in carbon dioxide emissions attributable to SPS proposal is 128.3 million for years 2022 through 2024. So that particular number is for all 3 years?
Yes, that's the cumulative number.
And within that comparison, does it increase or decrease, or is it pretty much the same?
The values are on page 13
Mm-hmm.
in the table.
Right, okay.
It increases slightly as the social cost of carbon is escalating, and the emission reductions are also escalating slightly.
Okay. And then at line 10, estimated value of the reduction of total emissions, including methane and what is N2O?
Nitrous oxide.
Nitrous oxide is 128.9 million for the years 2022 through 2024, correct?
That's correct.
So it's approximately $600,000 difference, correct?
Yes.
Why is the I guess that number surprised me. Could you just explain to me why it's only 600,000 for when you include everything? It's only 600,000 more, but I mean, obviously the carbon dioxide makes up the bulk.
Right. So methane and N2O emissions from power generation, so basically fuel combustion, are extremely, extremely small. If you have ideal complete combustion, they shouldn't be there at all. So really what you're having is a very, very small concentration of these things. They have higher global warming potentials when you convert them to a CO2 basis. So when you consider how much methane you have, how much it is on a CO2 equivalent basis, it's a bit more, but you're starting with such a low concentration that it really doesn't add very much to the overall total.
Because it seems like I keep hearing or reading, especially up in the Four Corners area, around Farmington. Are you familiar with that area?
I'm not, but if it's an area with oil and gas production, I have a sense of sort of where you're going.
Well, I think I have seen or heard about being able to see the methane from space, in that particular area. And I guess I'm kind of wondering, and I guess it's probably has been portrayed as, not the best thing. And I'm just wondering, well, with this representation of your numbers makes it look like it's not really that much of a big deal.
So it's a difference of what we would call combustion methane. So methane released during fuel combustion in our generation versus methane that is released either intentionally or accidentally through a leak or a damage that occurs during oil and gas production. And in those cases, the rates are much higher than they are in a combustion scenario. You have little methane associated with combustion, but you may have large amounts associated with industrial processes.
Okay, so when they refer to like methane flaring, that's different than the combustion methane.
Yeah, so methane flaring is combustion of methane, but it's a different. So when we burn natural gas, which is primarily methane, almost all of it is converted in the reaction to CO2. And there's a very, very tiny amount that doesn't get converted. When they're talking about methane flaring, usually that's either in a storage tank or a pipeline where they're letting off a little bit of methane to maintain pressure so that they don't have too much pressure build up in an enclosed container. And in that case, that's what the type of flaring that they're referring to, but that wouldn't happen at a power plant that's under normal operation.
And then so I also know that I've heard about methane. For example, there a number of years ago, I did a cheese factory case, and in the eastern part of New Mexico, and so there's a lot of cows there. And isn't methane also attributable to cows?
Methane is attributable to various dairy operations, yes.
And how does that compare when we're looking at, if we're talking about a little bit of methane for the generation, but potentially more through pipeline or process flaring, where does the cow generation of methane fit in?
I'd have to review US EPA most recent inventories to give you an exact number, but combustion methane is much, much smaller than any of these agricultural or industrial sources that are currently receiving a lot of attention.
Okay. All right, Dr. Leib, thank you very much. Been very interesting. Ms. Lees?
Examiner, I failed to ask Dr. Leib about the corrections to her rebuttal testimony, so I would like to do that now if that's acceptable to you.
Oh, okay.
Yep. Ms. Leib, were there corrections that you made to your rebuttal testimony?
Yes, there's one correction to my rebuttal testimony, which is that on pages 1 through 4, the header has been corrected to read rebuttal rather than originally it said direct.
Thank you. There was no substantive corrections to the testimony, correct?
No substantive corrections.
Besides correcting the word damages, the spelling of the word damages.
Right.
I have no more redirect, Your Honor.
Thank you. Anybody have any more questions for Dr. Leib? No. Okay. Well, thank you, Dr. Leib. Appreciate your time. You're excused.
Thank you.
Subject to do that calculation, please, and then report it to Ms. Lees. Okay?
Okay.
Very well. Thank you.
Thank you.
Ms. Lees, you have another witness.
Yes, Your Honor. SPS's next witness I would like to call is Mr. Luth. Is he in the waiting room?
He should be here shortly.
Great.
Ms. Lees, are these people appearing from different places, or are they being put in the Excel grilling room or the SPS grilling room?
They're all appearing from their offices,
Okay.
Your Honor, which are all SPS grilling rooms.
Oh, they all are.
No, they're all in their individual offices, whether that's on site or remote, depending on their location.
Okay, and I just wondered, because it seems like during the rate case that we had like a conference room type situation where people were being moved in and out.
The size of that case was so different, Your Honor. I mean, it was such a larger case that it's easier to do a remote hearing like this with witnesses being at their own remote locations.
Okay, great. Mr. Luth, are you there? I see your name, but I don't see your picture, and I don't see that you are.
Mike, it looks like you're still muted and you need to turn your camera on.
There you are.
All right.
Good afternoon.
Good afternoon.
SPS calls
Oh, okay. Go ahead, Ms. Lee.
Yeah, SPS calls its next witness, Richard M. Luth, to the stand. He's ready to be sworn in.
Very well. Would you please swear the witness?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Go ahead, Ms. Lees.
Good afternoon, Mr. Luth.
Good afternoon.
Do you have in front of you a document that has been marked as SPS Exhibit 7?
Yes.
Can you please identify that document?
Is my direct testimony in this case pre-filed July 1st?
I'm sorry, filed.
Pre-filed July 1st of this year?
And Mr. Luth, do you have any corrections to make to this document?
Yes, I have a few. Beginning on page 9, line 24, the amount of $660.05 should be replaced with the amount of $660.09. And then on page 13.
Mr. Luth, is the percentage still correct?
Yes, it is.
Okay, thank you.
Then on page 13, line number 9, the percentage of 0.25% should be 0.28%. And then on line 11, the amount of $3.09 should be replaced with $1.55. And then on line 12, the percentage should be changed from 0.25% to 0.23%.
And tell me again what the number was, sir, on line 11.
It had been $3.09.
Okay. And what is it now?
$1.55.
Thank you.
Thank you, Mr. Luth. I will represent to the hearing examiner that these corrections are noted in the copy that was sent to the hearing examiner and parties in this case.
Okay.
Mr. Luth, you do have attachments to your testimony, correct?
Yes, I do.
And were those attachments created by you or under your direct supervision and control?
Yes.
And if I were to ask you the same questions contained in this document today, would your answers be the same?
Yes.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
With that, Madam Hearing Examiner, SPS moves SPS Exhibit 7 into the record.
Any objection to what's been identified as Mr. Luth's direct testimony as corrected by him here today? Hearing no objections, SPS 7 is admitted.
And with that, Madam Hearing Examiner, SPS passes the witness for cross-examination.
Very well. Any questions for Mr. Luth from New Mexico Large Customer Group, Mr. Rushoff?
No questions from us. Thank you.
Okay. And from Occidental, Mr. McMillan?
No questions, Your Honor.
Okay, I thought somebody had questions that got asked Mr. Contreras questions that got passed on to Mr. Luth. Am I remembering that correctly, Mr. Rushoff or Mr. McMillan?
Your Honor, during my cross, there were some questions that got passed to Mr. Elsey, but
Okay.
I don't believe any of them were passed to Mr. Liu.
Okay, very well. Thank you. Any questions, Ms. Lynch from CCAE? Ms. Lynch? Your mute button.
Hearing examiner, sorry, I was muted.
Okay.
No, I don't have any questions. I appreciate it.
Thank you. Ms. Drake, you have questions for Mr. Luth?
No, thank you, ma'am.
Okay. And Mr. Bagatko, questions from staff?
Madam Hearing Examiner, I'm going to stay with the trend and state that we have no questions for Mr. Luth, but thank you, Mr. Luth, for being here today.
And I have a few for you, sir. Thank you for being here. So part of your assignment, sir, in this proceeding, as you indicate on page 4 of your testimony, beginning at lines 3 through 5, is to support SPS's calculation of the RPS rider and the reconciliation rider and the renewable performance rider, correct?
That is correct.
And when you take well, let's look at your testimony on page 9. The question posed at lines 3 through 5, what is the bill impact for each customer class, considering both the proposed RPS rider and reconciliation rider? And then you testify that under the proposed RPS and reconciliation rider, the difference is going to be 80 cents per month for you chose a residential customer utilizing 750 kWh per month, as set forth in lines 9 through 12. Is that correct?
That is correct, yes.
Okay. Can you just tell me how much of it is attributable to each of the two components?
I can refer to the attachment RML 7. I think it will be there.
Okay. Can you tell me which page?
Yes, that'll be page 1. And
Okay,
that is not correct, what I just said. It just has both riders in there in total. So I don't have it split between the two. Looking at the rates. Looking at the rates, it would be approximately 90% RPS rider and 10% of the reconciliation rider.
so looking at RML 7, page 1 of 10, and looking at the representative 750 kWh, and going to the last three numbers, the monthly bill at proposed RPS and that includes that one includes the performance rider. Correct? So that one would include all three of the riders, correct?
Yes.
Okay, so we're talking, if you include all three riders, you're talking 95 cents a month, correct? For the 750 kWh residential customer.
That's right, compared to the current RPS riders. And
Okay.
rider.
And so in your calculation of the components here, what's what? What's the percentage attributable to all three components?
Individually or in total?
Yes.
I don't have that in front of me. If I have split all three.
Okay.
It's 1.08, as you can see, for all three.
Right. Okay, consider that a bench request, Ms. Lees. I want to know of this proposed 95 cent a month increase. I want to know exactly how much it is for each of the three riders.
And Madam Hearing Examiner, just so I can get some clarification, do you want that only for residential 750 kWh? Or do you
I'd like
the
to see it for each of the representative classes that are in the witness's testimony.
So that's
mean,
that is something that's going to take longer for us to get to than today. So we will file that into the docket.
Okay. I mean, he gives the typical bill impact for various groups under the renewable performance rider. So, I mean, I think that would be pretty easy to see that. And then he gives and that's on pages 12 and 13, but then on pages 9 and 10, he says, what's the bill impact for the proposed RPS and reconciliation rider? And he gives that. So I think he probably could just, for each one of those categories, I want to know how much it is together with all three, and then separate out the three, the three parts.
So just so I'm clear, You want the bill impacts with the percentage increase broken out by each individual rider.
Well, not just the percentage, but I also want to know how much. So,
Okay, and the dollar increase.
Right,
Or,
yeah.
Yeah.
Right. I mean, I can read 750 is gonna, and I can, get my abacus out and, look at 82.91, whatever, and figure those, but, they're his numbers and I just want to see them so that when the commission says, well, okay, Elizabeth, what's the bottom line here? If it's, the bottom line was 96 cents and 16 cents of that is going to be the performance rider. And then this percent, and that's X percent, that's 14.25% of the total. And then the other part is this much. And okay.
That makes sense to me. Let's confirm that Mr. Luth understands what he's supposed to be providing as well.
Mr. Luth, can you do that for me?
Yes, I'll provide the change in dollars as well as the percentage for each of the three proposed riders.
For the categories that you chose, which, I always have fun with this with SPS. No one, it seems like the others are more happy to say average or whatever, but I think it was SPS that used to say the typical customer. And so I'm assuming that's what you chose in your testimony. Is that correct?
That's correct. In round numbers, we didn't get it down to the kilowatt hour.
Okay.
It changes every single year.
Okay.
So we try to maintain comparisons between cases.
Okay.
In a situation such as this.
And I'm assuming, that, you're putting in a representative number of that class. So, I don't have any, I don't have any criticism for that. I just, like I say, I just want to see what the actual numbers are for each one of those and how that translates into percentage. And with that, that's all the questions that I had for you, sir. Ms. Lees, any redirect?
No, Your Honor.
Okay. And hopefully you can get that this week. Can we get that this week, Mr. Luth?
Yes, ma'am.
Okay.
Certainly.
Okay. Anybody else have any questions based on my questions? No. All right. Thank you, sir. You're excused.
Thank
Ms.
you.
Lees, anything further from SPS?
No further witnesses, Your Honor. Thank you.
Thank you. And I believe then in our order of presentation, Mr. Rushoff, you have a witness.
Yes, Kevin Higgins should be in the waiting room. If he's
He
not there.
is. Hello there, Mr. Higgins. Just need to unmute yourself.
Good afternoon, Your Honor.
Good afternoon. Mr. Rushoff.
Yes, the New Mexico Large Customer Group
There you go.
calls Mr. Kevin Higgins to be sworn in.
And Ms. Gonzalez, would you please swear in Mr. Higgins?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good afternoon, Mr. Higgins.
Good afternoon, Mr. Rorschach.
Could you please state your full name for the record?
Yes, my name is Kevin C. Higgins. Did you ask me to spell it?
I did not.
Okay.
Do you have a copy of your direct testimony before you, which has been marked as NMLCG Exhibit 1?
Yes, I do.
And do you have any corrections to make to that testimony?
I do not.
And if I were to ask you the questions contained in your direct testimony, would your answers be the same today as they are in the testimony?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
And to confirm, you do not have any attachments to your direct testimony, correct?
That is correct.
Okay. Madam Hearing Examiner, I would move for admission of Exhibit NMLCG 1.
Any objection to what's been identified as NMLCG 1, Mr. Higgins' direct testimony as verified by him here today? Hearing no objection, NMLCG 1 is admitted. Mr. Rushaw.
Yes, thank you. And Mr. Higgins is available for questions.
Very well. Ms. Lees, any questions for Mr. Higgins?
Good afternoon, Your Honor. This is Will Du Bois for
Hi,
Southwestern
Mr. Du Bois.
Service. Hello.
Is this your witness?
It is, Your Honor.
Okay, go ahead, Mr. Du Bois.
Thank you, Your Honor. And
Thank you.
Good afternoon, Mr. Higgins.
Good afternoon, Mr. Du Bois.
And stay right off the bat, if you do have any difficulty hearing me or understanding the
Oops.
Lost you. You went on mute, Mr. Du Bois. Still on mute. And we've lost your video feed too.
Madam Hearing Examiner, I will call Mr. Du Bois right now to see what's going on.
Okay.
Mr. Du Bois, I just talked to him. He said he's waiting in the waiting room to be let back in.
Uh-huh. There you are.
My apologies, Your Honor, and Mr. Higgins. I'm shocked, I guess not surprised at how quickly I had to resort to a backup computer. But
And let me just say, Mr. Higgins, just for the benefit of the court reporter, if you are referencing a B as in boy or D as in dog, if you would just reference a word just so that we're really clear with which section of the rule or the statute that we're talking, she would appreciate it.
Certainly.
Okay. Thank you. Go ahead, Mr. Du Bois.
Again, good afternoon, Mr. Higgins. I'm not sure exactly where the computer quit, but as I was trying to say, if I have any breaking up, if you can't hear my questions or if you don't understand, please do let me know and we'll go from there.
I will.
Okay. I'd like to start on page 2 of your testimony at lines 7 to 9. Let me know when you're there, please.
I'm there.
I'll preface my question that I'm not certainly at this point asking you to identify any of your clients, but with respect to your statement there that you assist private and public sector clients, are any of those clients regulated electric public utilities?
Typically, no.
typically know, are there any, we'll say at this time?
No.
And are any retail electric providers who are subject to a renewable portfolio standard?
Yes.
Have you advised any of those clients in favor of exceeding their requirements under a state renewable portfolio standard?
No.
Are you aware of any of them having exceeded a renewable portfolio standard voluntarily?
Not to my knowledge.
Do you think those clients would derive a reputational or a public benefit from exceeding their applicable renewable portfolio standard?
Perhaps. I have not had such discussions with any clients about that.
Okay.
I don't want to presume how they would, what value they would put on it themselves.
Okay. Could you please turn to page 3 of your testimony?
Yes.
And there is a Q&A regarding whether you've testified before utility regulatory commissions in other states, correct?
Yes.
And in your testimonies in any of those states, have you advocated for any regulated electric utilities to surpass a renewable portfolio standard?
I don't believe so.
Are you aware of any of the utilities regarding which you've testified voluntarily exceeding a renewable portfolio standard?
Well, that's a long list of utilities that I've had the opportunity to be in proceedings with. So I sitting here now, I cannot say that I comprehensively know whether any of them have exceeded renewable portfolio standards voluntarily. And so but I can say that I'm not specifically aware of any instances. That that doesn't rule out the fact that the possibility that there are some that could have done so without my specific knowledge.
And so there are some that
could have done so without my specific knowledge.
Thank you.
And we've been talking a little bit about exceeding or surpassing the renewable portfolio standard, but turning more specifically to New Mexico's, do you have an opinion under the Renewable Energy Act how a utility would demonstrate exceeding the applicable standard in a way that would justify a incentive?
It seems to me that in the future, if SPS develops a proposal that would both exceed the requirements and provide the opportunity for cost savings to customers, that might be one option that could be considered.
Okay, and I think there's a few things in that answer that I'd like to unpack. First off, would you, in your expert opinion, say that the way for a utility to, as a factual matter, demonstrate that it is exceeding the RPS be to retire renewable energy credits in excess of the annual standard?
That's my understanding of the mechanics as to how that would work.
Are you, or do you have an opinion as to any other way that demonstration of exceedance could be made?
Not specifically within the context of the New Mexico requirements.
Would you agree that under the New Mexico Renewable Energy Act, a utility could demonstrate surpassing or exceeding the annual standard based on its generation mix in that year without regard to its position on retiring renewable energy credits?
If there's a provision you could point me to, I'd be happy to take a look at that.
Okay. Maybe if you could refer to New Mexico Code 62-16-4D, as in dog.
I can get to that, but not without losing my Zoom screen.
Just one second.
Actually, I think, Your Honor, I apologize, I think you were already in the right statute. We're just a few sections below.
Okay, which section are you referring to, Mr. Du Bois?
Subsection D, as in dog, Your Honor.
Okay. Okay.
Thank you, Your Honor.
Thank
So,
you.
Mr. Higgins, I would refer you to this subsection D, and in particular to the language in the 3rd to 4 lines, encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standard set forth in this section. Do you see that?
Yes, I do.
Would you like a moment to review that?
Just one moment, please. Yes, I see that.
Okay. So just focusing on the phrase exceeds the applicable annual renewable portfolio standard. Would you agree that a utility could demonstrate that exceedance based on its generation mix for that year, regardless of its position with respect to retiring RECs for RPS compliance in that year?
I guess I'm not comfortable trying to draw a legal interpretation of the word exceedance here, Mr. Du Bois. I can certainly see that in a very common usage of exceed, that the phrase you're referring to could be accomplished if the utility has acquired renewable energy in a way that is greater than the requirement. As to whether it would exceed for purposes of the rule or the law, my understanding is that the utility would have to retire RECs to validate that exceedance. But that's just my non-legal understanding.
Would you agree that you're providing at least some legal interpretations via your testimony?
My testimony really addresses primarily the policy issues that are pertinent here. Obviously, it's not possible to completely not discuss the law that's a framework behind it. And so my references to the statute and the rules are consistent with my non-legal understanding of it, but my understanding as someone who's an expert in utility rate making matters.
Do I understand then your testimony to be that you are making policy recommendations that may or may not be consistent with or based on the statutory text of the Renewable Energy Act?
My recommendations are consistent with the statutory text as I understand it.
But you're not sure if your recommendations are consistent with this particular provision?
Well, as I said, you were asking me about the use of the word exceed. And I would say that the framework of your question strikes me quite candidly to be a little bit of a trap, in that the company's own application here requests an incentive for retiring RECs early, and posits that as I understand the company's application, that is the vehicle for exceeding the standard that is currently in place. So it's a premise of the company's application that the retirement of RECs is the mechanism through which the company would achieve the exceedance. If that weren't the case, one could simply observe that the current level of generation that the company has in place today, but for the retirement of the RECs, could very well exceed the requirements of the law. But the company, in order to take credit for that, is seeking to retire RECs. And so that's maybe a fuller explanation as to my understanding of the relationship between the word exceed, as used in your question, and the retirement of RECs.
If Southwestern Public Service Company or another New Mexico utility were proposing to demonstrate exceedance based on its generation mix, while only retiring RECs sufficient to meet the annual standard, would it be your testimony that that could provide a viable foundation for earning an incentive?
I'm going to object. I think Mr. Higgins has explained that he's not comfortable interpreting the statute as it relates to the word exceedance, and I think his positions are clear on how he applied the language of the statute in his testimony.
Mr. Du Bois?
Your Honor, I think the hypothetical is a different question than I've asked previously.
And you want to restate the hypothetical for me, Mr. Du Bois?
Certainly, Your Honor. My hypothetical question is, if Mr. Higgins were reviewing an application for an incentive under the RPS or under the Renewable Energy Act that was based on a generation mix that provided renewables in excess of the annual standard, but did not offer to retire RECs in exceedance of the requirement to meet the annual standard, would Mr. Higgins agree that that could form the basis for an earning an incentive, notwithstanding his opinion on cost benefit comparison or other issues.
So in your hypothetical, you're talking about actually generating new renewable energy?
Generating renewable energy without respect to whether it's from new sources or existing sources, Your Honor.
Does that clarify for you, Mr. Rushoff? It's a different question?
Yes, I would still say that I don't believe such a scenario was addressed by Mr. Higgins in his testimony. And I believe the rules and the statute are clear that the financial incentives require retiring recs. So I would stay with the objection.
Okay,
If
I'm
Mr.
going to
Higgins-
overrule your objection, and I'm going to answer if you know, Mr. Higgins.
Well, let me first say that this hypothetical question does not represent the application before us today. And if the application before the commission were the type of application that Mr. Du Bois is describing in his hypothetical, then I would have to assess that application on its merit. Sitting here today, I can't tell you whether I believe that that hypothetical would reasonably qualify for an incentive mechanism based on my understanding of commission's rules and the statute.
I'm sorry, my understanding of, please speak up.
The commission's rules and the statute that speak to this issue.
Go ahead, Mr. Du Bois.
Thank you. Mr. Higgins, do you understand the answer you just gave to be inconsistent with what Mr. Rushoff just offered, that exceedance would have to be demonstrated by retiring renewable energy credits in excess of the annual standard?
No, I do not consider my answer to be inconsistent with what Mr. Rushoff said. I said that I couldn't, sitting here today, I could not provide an assessment of the hypothetical and whether an incentive would be applicable under the hypothetical, as that is not the application that the company made. And it is not a proposal that I've had a chance to consider or to discuss with counsel with respect to whether it would qualify legally.
So going back to this subsection D, it's safe to say the provision does not make any reference to a showing of a benefit, correct?
Not within the four corners of this provision D.
Are you aware of anything elsewhere in the Renewable Energy Act that refers to a showing of a benefit associated with the Renewable Energy Act's incentive?
Not specifically not specifically to the word benefit, although I do believe that the Act does acknowledge that cost considerations should also be considered.
I promise we'll get to costs, Mr. Higgins, but just focusing on benefits for the moment. Are you aware of anywhere else in the Renewable Energy Act that discusses benefits in the context of earning an incentive?
I am not specifically aware of that.
You do discuss a cost benefit analysis associated with earning the incentive in your testimony, correct?
Yes.
In your opinion, could you please identify a benefit that comes from retiring renewable energy credits to meet an annual renewable portfolio standard in New Mexico?
I don't see a benefit directly from the mere act of retiring the RECs. The benefit would be associated with what the RECs that were originally generated represent.
So what is a benefit that the RECs that were originally generated represent?
Well, the benefit is, as I understand it, is related to, for example, the reduction of carbon dioxide emissions. I interpret that to be the primary benefit, as I understand the Act, although the Act does refer to other benefits. I should say that other attributes, that other policy goals.
I'm sorry, the policy goals?
Yes, that the state has.
What policy goals would those be?
I'd appreciate a moment to be able to review the statute.
Certainly.
If it would be, Your Honor, if you, okay, thank you. Or I would, I could also do that with my own computer, but it would be necessary for the Zoom screen to be smaller. Your Honor, is it, since you seem to be controlling the screen that I'm seeing, is it possible to make it slightly smaller?
How's that?
Actually, I think I need to make a change in my end. I've got it. Thank you. Sorry about that. Well, I would add that the act refers to economic development opportunities. Is part of the reporting requirements that a utility will prepare. And so I infer that economic development development opportunities is one of the benefits that the legislature may have had in mind, besides reduction of carbon dioxide emissions.
As to carbon dioxide emissions, are you aware that biomass resources are among the generating resources that qualify as renewable energy under the New Mexico Renewable Energy Act?
Yes.
Subject to a showing that they have zero life cycle carbon emissions, correct?
Correct.
But that doesn't require a showing of carbon emissions reductions associated with them, correct?
Well, there is the zero carbon lifetime of demonstration, as you pointed out.
I'm sorry, lifetime what?
Demonstration, as you pointed out.
And it's not a negative carbon demonstration, correct?
Correct.
So hypothetically, a utility could meet its entire RPS obligation without reducing emissions at all, correct?
Well, that's quite a stretch of a hypothetical. That is, meeting the obligation strictly through biomass resources. And I can't say I can answer your question without reviewing it in the context of the entire act. But I would agree that insofar as this particular resource is concerned, I would agree that a net reduction in carbon dioxide does not appear to be.
And the New Mexico Renewable Energy Act does not require that generating resources be located in New Mexico in order to qualify, correct?
That's my understanding.
Do you believe that a generating resource located outside of New Mexico provides an economic benefit to New Mexico so long as it generates electricity that is delivered into New Mexico and the associated renewable energy credits are retired for New Mexico compliance or exceedance of the standard?
Yes.
Beyond those two, can you think of any other benefits that come from renewable energy that is generated for the use of or is ultimately used by New Mexico customers with the associated renewable energy credits being retired in New Mexico?
So you're including the reduction of carbon dioxide in your proposal?
Yes, sir. Those are the two: reduction of carbon dioxide and economic benefits.
I'm not aware of others at the moment.
Would energy security be a potential benefit?
Well, I would agree that energy security, diversity of supply are benefits that come from adding additional resources to a utilities portfolio.
Would you agree that electric price stability is a benefit?
Yes.
Do you have an opinion on how to quantify the benefits of fuel diversity, electric price stability? We'll just start there.
The benefits of fuel diversity is something that can be reasonably addressed as part of an integrated resource plan.
Do you have an opinion on how it could be quantified for the purposes of a cost-benefit analysis required for a showing under the incentive provision of the Commission's Rule 572?
I am not aware of specific guidance in the rule as to the quantification of fuel diversity benefits.
So renewables provide at least some benefits that are unquantifiable for the purposes of a numeric cost-benefit analysis under the rule, correct?
Not entirely. Again, I referred earlier to cost, and I do believe that the rule provides an avenue for evaluating cost effectiveness. It is related to the cost effectiveness of reducing carbon dioxide emissions, but it does speak to the general cost effectiveness of an investment that the utility might undertake in complying with the Act.
We may come back to benefits, but we'll go ahead and talk about costs on Mr. Higgins. If you could please refer, and Your Honor, if you could perhaps please turn to REA's section 4, paragraph or subsection E, beginning if in any given year. Yes, thank you, Your Honor. If you'd like, please take a moment to review that provision, Mr. Higgins.
Thank you.
And just let us know when you're ready.
I'm ready.
Great. I'd like to focus for the moment on the sentence that picks up in the 6th line, stating the provisions of this subsection do not preclude a public utility from accepting a project with a cost that would exceed the reasonable cost threshold. Do you see that?
Yes.
And do you understand that the reasonable cost threshold is at this time approximately $60?
Yes, that is my understanding.
So if a utility had an opportunity to procure a renewable resource that was, say, $65, this provision would indicate that the utility would be able to accept such a project, correct?
Yes, it indicates the utility would not be precluded from doing so.
I'd like to explore something we touched on earlier regarding the ability. consistent with your testimony for any utility to be able to earn an incentive. First off, would you agree that under the framework you present in your testimony, no utility could possibly earn an incentive?
No, I do not agree with that.
Okay. Could you please turn to your testimony at page 4?
Yes.
And I'd like to pick up at line 12 there.
Okay.
You make an argument there about how banked RECs should be used, correct?
Yes.
And you say that banked RECs should only be used for essentially future compliance purposes, correct?
For the future benefit of customers, yes.
And what future benefit of customers are you referring to, if any, other than retiring those RECs in the future in order to meet but not exceed the annual standard?
Well, with respect to banked RECs, I would agree with your characterization. That's that does not demonstrate that under my position that no utility could earn an incentive in the future.
Okay, well, focusing just on those already banked RECs, we'll call them, for the moment. Is it your testimony that banked RECs should only be used for subsequent compliance with the annual standard? Excuse me.
Yes.
For a utility that generates in a year credits that exceed its obligation to meet the standard in that year, would your opinion be that those RECs must similarly be banked for future compliance, or is it your opinion that those RECs could be retired in that year to earn an incentive?
I believe that hypothetically, they could be retired in that year to earn an incentive if it was part of a program approved by the commission that included a demonstration that the investment was cost effective according to the standards set out in the commission rules. And in my view, that would mean a program that was going to reduce costs to customers below what they would otherwise be. So that would be the type of program that I believe would make a credible showing for a request for an incentive. And it's possible, hypothetically, that as part of such a program that reduced costs to customers, that retiring RECs in excess of the standard might be possible. Again, this is a hypothetical, but you know, that may be possible.
Well, Mr. Higgins, do you understand that Southwestern Public Service Company is generating in the year we are looking at here for earning an incentive renewable energy credits that exceed its annual obligation?
Yes.
And do you understand that generation to be cost effective for customers?
Yes.
So have we not just met the standard you articulated?
My I would say my understanding is no, because the particular resources you are using are ones that, for which you did not, as I understand it, apply for such an incentive, is part of getting them approved. And so in answering your question, my answer is directed on a going forward basis. And I was positing that it would be possible, I believe, in the future to make a proposal that would qualify in the future for an incentive under the general terms that I described. But I do not believe that it is applicable retroactively to the Hale and Sagamore projects.
So is it your testimony then that to earn an incentive, a utility would have to come into one of these annual cases proposing that in the future it will build renewable generation that would exceed a future annual standard if and only if it is given an incentive to do so?
I would say that that is one possible path forward. I'm not saying it's the only path forward, but that's a possible path forward.
Can you name another path forward, please?
It would not necessarily have to be in one of these RPS proceedings, I suppose. It could be, I would imagine it might be linked to a request to proceed with the project. So I'm not saying that only these proceedings would might be the only appropriate venue. I don't know. I'm just trying to say that I wouldn't rule that, rule out that there might be other venues possible.
If you're aware, do you know that under Rule 572, the only time incentive can be sought is in one of these annual cases?
Well, I would accept your representation.
But you're not aware either way?
I'm not aware.
Okay. Can you please state for us the cost, in your opinion, or what you would look at to find a cost, in your opinion, of exceeding the renewable portfolio standard in a given year just by one renewable energy credit, just for simplicity's sake?
Could you repeat the question? I'm not sure I followed it.
Sure, and I'll even reorganize it for you. If we just look at the idea of exceeding the annual standard by one renewable energy credit, one REC, how would you go about identifying the cost of exceeding the standard by that one REC?
I would look at the cost of generating the underlying electric power that made that possible.
Okay. And are there any other costs that you would look at?
Well, it would include the cost of generating the electric power, as well as the cost, if applicable, of any renewable energy attributes that went along with it. So it would be the totality of the cost of generating or acquiring that energy resource. But I would, there may be, a part of that would be the, costs associated with transmitting it. If there are other costs associated with being able to use the power, those would also have to be.
When you referred in your answer to, quote, the cost of renewable energy attributes, Mr. Higgins, I didn't follow what you meant by that. Can you identify for me what a cost of a renewable energy attribute would be in this context?
Yes, if it was a resource that was being procured by the company, then my understanding is sometimes the renewable energy attributes are priced separately in that type of acquisition. So there's the cost of the underlying energy, but then the renewable energy attribute is sometimes included as part of the cost or the price. So that's what I'm referring to.
I'm sorry, I didn't catch the last thing. Included as part of the cost of the price.
Could you please read to me the earlier part of that answer?
Yep. Yes, if it was a resource that was being procured by the company, then my understanding is sometimes the renewable energy attributes are priced separately in that type of acquisition. So there's the cost of that underlying energy, but then the renewable energy attribute is sometimes included as part of the cost of the price.
Cost or the price of the acquisition.
Shall I continue?
How you doing there, Mr. Du Bois? How much more you got?
Well, it has taken longer than I expected to get here, Your Honor, so I hesitate, but I'm not exactly almost done. If you're looking at whether to take a break now, I'd say now might be a good time.
Ms. Gonzalez, ready for a break?
Sure.
Okay. It had been represented to me that there's not more than 30 minutes for each witness. I plan on finishing today, so let's keep that in mind. And we will take, I have 2:56. So let's come back at, let's take 10 minutes. We'll come back at, I'll give you the 4 minutes. We'll come back at 3:10 and you can ask a few more questions, Mr. Du Bois.
Thank you, Your Honor.
Thank you. Okay, I think we are back from our recess. It's 3:10. Mr. Du Bois, you had a few more questions.
Thank you, Your Honor.
Go ahead.
Mr. Higgins, yeah, thank you. Can you please go to page 11 of your testimony, lines 11 to 12?
Yes, I'm there.
And there you state, quote, "It appears that the intent of the REA is to expand the use of renewable energy resources, comma, but not at any cost," end of the quote, correct?
Correct.
And in fact, we know the minimum cost that we think the legislature believes to be justified, correct?
I'm sorry, believes to what?
Be justified.
I'm not sure I follow your question regarding the minimum cost.
But we talked earlier about the reasonable cost threshold. Do you recall that?
Yes.
And under the reasonable cost threshold, the legislature has stated that any cost up to at least $60 is merited, correct?
Correct. I did not see that or interpret that as a minimum cost, but yes, I'm aware of that threshold.
Well, we do have E, subsection E, where the reasonable cost threshold is discussed on the screen still. And we agreed earlier that a utility could not be precluded from going over the reasonable cost threshold if it volunteered to do so, correct?
Correct.
It just couldn't be forced to.
Sorry.
I'm sorry, please go ahead.
I'm sorry. Well, I talked over you. Perhaps you should finish.
If you had more answer, please provide it.
My answer was really a response to say that I recall this exchange in our discussion, but I still don't see the relationship between this reasonable cost threshold and minimum cost. That is, it would seem that something less than this cost would also be reasonable in terms of the statute.
If a resource costs $60, it meets the reasonable cost threshold, correct?
Yes. And if it costs $50,
doesn't that necessarily?
I'm sorry. Please finish your question.
Doesn't that necessarily mean that the legislature believes that the benefits of energy associated with that renewable energy credit is at least $60?
One could probably infer that.
Well, if the legislature thought that the benefit could be $30, but set the reasonable cost threshold at $60, the legislature would be communicating that it endorsed costs exceeding benefits, correct?
Correct.
Do you believe the legislature was endorsing the view that costs could exceed benefits and it would still be merited to acquire the renewable energy?
No, and I believe in my prior answer, I was fundamentally agreeing with the question you asked me.
Okay, I apologize if I misunderstood, but just to be clear, you would agree then that the legislature believed that the benefits of the energy associated with the renewable energy credit has to be at least $60 in order for the benefits and the costs to match, and that further, you've already stated that the legislature, in your opinion, did not mean to allow the costs to exceed the benefit.
Yes, and my answer to your prior question was about whether I thought the legislature, one could conclude that the legislature attributed benefits from renewable energy to be $60 per megawatt hour. I said that one could probably reasonably infer that.
Okay. And changing gears slightly, if you could look at the last sentence, and particularly the last phrase of subsection E, quote, and shall not be precluded from exceeding the standard, quote, end quote. That makes it clear that the utility's ability to acquire up to $60 energy or incur $60 as the level of costs for the energy associated with renewable energy credit also allows the utility to go over the standard, correct?
Could you please repeat the question?
You know what, I think you probably already answered the better version of that question earlier. We can move on to subsection 5 of the statute, please. I'm sorry, section 5, subsection B as in boy, 2. And if you could please refer to the last full sentence under 2 before it gets to the sub A. I'll represent it states, quote, the commission shall not disallow the recovery of the costs associated with any expired renewable energy certificate, end quote. Do you see that?
Yes, I do.
And I assume you agree with it as a statement of law, correct?
Yes.
So combining this idea and the last idea we were discussing, isn't it true that a utility could procure $60 or could incur a cost of $60 for the energy associated and the REC itself associated with a renewable energy credit, and then allow that same credit to expire unused, and the legislature still thinks that cost is merited, correct?
That appears to be the case.
Okay. Okay, and I'll try to briefly wrap up one thing that we left off on and had moved on, but I'll see if we can finish it on the subject of RECs generated in a given year in excess of the standard. Is it your understanding that, or belief or opinion, that those RECs would need to be banked for future use by customers and not retired in that year?
My statement about that in my testimony is a policy prescription that I support, although it was made in the context of existing banked RECs. I cannot rule out a hypothetical situation in the future in which the company develops a program that would allow excess RECs produced in a given year to be retired within the framework of an overall proposal, an overall package that provided benefits to customers. So it's a hypothetical, and I would say that from my standpoint, one would review such a proposal on its merit. Yeah, I would, that said, I would, absent such a proposal, absent such a demonstration that it would produce benefits for customers, that as a general proposition, I do continue to maintain that banked RECs should be used for the benefit of customers to meet the required standards.
Isn't your policy recommendation on this point plainly contradicted by the statutory language that not only does not require banked RECs to be used for customers, but explicitly says that the commission, quote, shall not disallow the recovery of the cost associated with any expired renewable energy credit, end quote?
I don't believe so. And also I certainly don't believe that my recommendation in this case, which pertains to the company's request to be paid an incentive for retiring banked RECs, I certainly don't believe that that contradicts what is in the legislation.
Couldn't a hypothetical utility that has banked RECs simply sit on them and allow them to expire unused, and that be endorsed by the legislature?
What was that you said about endorsed? I didn't hear the words.
Endorsed by the legislature.
Say, and not be endorsed? I'm sorry, Mr. Du Bois, I didn't hear what you said.
I'll ask the whole question again.
Thank you.
Couldn't a hypothetical utility have a banked REC position, and rather than using them for Renewable Energy Act compliance in any given year or earning an incentive, simply allow them to expire? Start there.
That appears to be possible.
And in fact, the legislature has explicitly made that possible and endorsed that possibility, correct?
I don't know about the word endorse that possibility, but it does speak to the fact that the costs would not be disallowed, as I understand.
What do you think in this sentence that we've been looking at, that the commission shall not disallow the recovery of the cost associated with any expired renewable energy certificate, falls short of an endorsement?
An endorsement to me is typically a proactive statement of support. And I don't read this language as specifically encouraging utilities to allow RECs to expire. I read it as saying that if that should happen, that there would not be a disallowance of costs associated with that. I don't see that as a proactive support of allowing them to expire.
The legislature, in fact, encourages utilities to retire RECs early in order to exceed the renewable portfolio standard, correct?
That is my understanding.
Okay. Thank you, Mr. Higgins. Thank you, Your Honor. That's all I have.
Very well. Thank you, Mr. Du Bois. Mr. McMillan, any questions for Mr. Higgins?
No questions for Mr. Higgins, Your Honor.
Ms. Lynch, any questions? Ms. Lynch, you're muted. Ms. Drake, anything from you?
No, ma'am. Thank you.
Thank you. Mr. Bagatko, any questions from you?
No questions for Mr. Higgins, but we thank him for his testimony in this case, Madam Hearing Examiner.
Thank you, Mr. Bagatko. Oh, good afternoon, Mr. Higgins.
Good afternoon, Your Honor.
How are you doing?
I'm doing great, thank you.
Excellent. I think I pretty much understood your testimony, although based on some testimony that I've already heard and some positions, I just generally wanted to ask you, one of the first questions that that I believe it was your counsel asked one of the SPS witnesses is whether or not he thought there was a conflict between the rule and the statute. And I think it's SPS position that yes, in fact, that they believe that there is a conflict with Rule 572 and the REA. Do you believe there's a conflict between the commission's, especially the new part of the of Rule 572 and the REA?
No, I do not. I believe that the commission's rule provides a specific means for determining the cost effectiveness of an action that was intended to receive or is proposed to receive an incentive.
And to the best of your knowledge, did your client participate in the rulemaking? If you know,
I'm not aware, Your Honor.
and could I conclude, Mr. Higgins, from reading your testimony, that your primary source of disagreement as to SPS's incentive proposal has to do with the cost benefit analysis of the proposed incentive?
Your Honor, that is a major threshold objection that I registered to the company's proposal. But I also believe that the basic proposal the company's making runs contrary to customer interests. I think that a proposal to have customers pay SPS an incentive to retire renewable energy certificates that the customers have essentially already paid for, and which would otherwise be used to meet the RPS requirements going forward, is harmful to customers. That in essence, in this particular instance, the company is not proposing any new actions. It's not proposing any new investment. It simply wants customers, or asks that customers pay an incentive for retiring banked renewable energy certificates. And so in my view, customers are in essence disadvantaged in several ways. First of all, they've already funded the cost of the renewable energy certificates in their rates that have been banked. Then, secondly, they would be paying an incentive to the company to use them. And third, they would be having to not be credited with having met the renewable portfolio standard in those later years when the banked recs could otherwise be applied. So I believe that in addition to not passing the cost benefit test, the proposal runs directly contrary to customer interests.
Okay, so you don't have a specific objection to the timing of the proposed incentive.
Ron, when you say the timing, could you help me?
Yeah, for example, I think there are other parties, including the staff, who basically say that the interpretation of the new incentive section says in the rule says that it's for actions or measures that occur after the effective date of this rule. And the way I read your testimony is you're not saying, for example, oh, the commission ought not to allow this because, you know, of this time frame. That you're not saying that, are you?
I do not have testimony in my direct testimony that makes that argument, but I do not disagree with the arguments that have been made by other parties on that point.
But yours, as you've just explained to me, and as you say, for example, on page 4 of your testimony, when you're giving your conclusions and your recommendations, you talk about future benefit, and you've just testified. So it seems like to me that your disagreement with the incentive is broader than just tying it to a time frame.
I believe that's true. I think that with regard to this particular proposal,
okay,
it is, in my view, it's extraordinarily narrow, and it's requesting an incentive payment that is not tied to any proactive investment proposal going forward. And so I find it highly problematic.
Thank you, sir. Mr. Rushoff, any redirect for your witness?
Yes, just briefly. Mr. Higgins, we've covered a lot of territory here in a lot of the Renewable Energy Act. So I just want to kind of clarify the position, the pieces of the Renewable Energy Act, the incentive piece, and how it relates to your testimony. So if you could please look, or we could bring up on the screen, Renewable Energy Act section 62.16.4, which is the RPS section, and just subsection A. And in that subsection A, is it your understanding that a utility must retire RECs to demonstrate any level of compliance with the RPS? And specifically, I can point you to the language in the second and third lines of that subsection A.
Yes, that is my understanding.
And moving to subsection D, which is the portion specific to the financial incentive. And I will point you to the language starting towards the end of the second line there. Following, it says, open a docket, and we're talking about the financial incentives. It says to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the RPS. Do you see that language?
Am I in the right place?
I'm seeing, nope, no, I'm not seeing it.
Okay,
you were in the
16(4)D.
D is in dog, I'm sorry.
Right, okay,
I missed your direction earlier to
okay.
clarify. So again, I'm looking at that language specifically where it says financial incentives encourage public utilities to produce or acquire renewable energy. Do you see that language?
Yes, I do.
And that's, again, this is the subsection in the context of financial incentives that SPS is basing its request on, correct?
Yes.
And so in your opinion, does this subsection D, as in dog, of the REA require something more than simply retiring banked RECs to earn an incentive?
Well, it requires, an application to the commission. So it requires getting approval, from the commission for any incentive.
Yes. Specifically, the language about producing and acquiring renewable energy, does that indicate something more than simply retiring previously acquired banked RECs?
Yes, it requires, I read that is to require some affirmative step to, as the statute says, produce or acquire renewable energy. That is, it is indicative of a forward-going action.
And it's your understanding, correct, that SPS has not proposed to acquire or invest in any new renewable resources in this proceeding, correct?
Yes.
Thank you. And there was some discussion with Mr. Du Bois earlier about accelerated retirement of resources. Is it your understanding that SPS has not proposed to accelerate the retirement of any current resources in this proceeding either?
That is correct.
Okay. Those are all my questions on redirect.
Mr. Du Bois, anything further?
I'm afraid so, Your Honor. I think some of these answers seem to me inconsistent with some of the answers I received, if I may, Your Honor.
Go ahead, sir.
Picking up at the end, Mr. Higgins, help me understand, is it your testimony that the incentive is to newly procure or newly acquire renewable resources rather than to retire renewable energy credits?
The phrasing seems to be clearly directed toward encouraging utilities to produce or acquire. And so I would say, yes, the retirement of RECs is a mechanical action that happens to, I believe is essentially part of a certification process or keeping track of the, the math, if you will. But regarding incentives, it appears to be geared toward taking a forward-going action.
Okay. And with respect to hearing examiner Hurst's question about whether the rule and statute conflict, didn't you agree, or wouldn't you agree, that they conflict at least with respect to the use of biomass?
Do you know, Mr. Higgins?
I'm thinking, Your Honor.
Okay.
I would say it's possible that the that the use of biomass might. It's possible that the test, or the cost benefit analysis required in the rule may not be specifically applicable to biomass. I suppose that's possible.
The legislature didn't say a utility can't meet or exceed the renewable portfolio standard with biomass, right?
It did not say that.
Do you know if SPS even has any biomass, Mr. Higgins?
Not to my knowledge.
Are you familiar with EPE's failed biomass project?
I'm not specifically familiar with that, Your Honor.
Go ahead, Mr. Du Bois.
Thank you, Your Honor. You indicated in your testimony in response to hearing examiner Hurst, I'll try to get the words right, but this may be a paraphrase, so please tell me if you disagree with this characterization, that customers are disadvantaged if renewable energy credit is retired early. Do you recall that?
I said customers are disadvantaged under the company's proposal for a financial incentive.
But not because the renewable energy credits would be retired early?
They would be disadvantaged because the company is asking customers to pay for that early retirement. And it is possible that it would have some negative cost consequences for customers in the future.
What do you mean by pay for that early retirement?
Through a financial incentive.
So a financial incentive harms customers, correct?
In the context of the company's proposal, I believe the company's proposal is harmful to customers.
A financial incentive would always cost customers money, correct?
That is correct. It would always cost customers money.
Can you come up with a hypothetical where that cost would not be a harm to customers?
If it was in the context of an overall proposal that produced benefits to customers and the financial incentive taken into account did not cause the overall costs to customers to be negative.
Wouldn't customers get more benefit with no financial incentive?
In isolation, yes.
So isn't the financial incentive therefore a harm to customers by reducing the benefit?
I believe I've answered your question, Mr. Du Bois. I said that if the financial incentive was incorporated into a larger proposal that provided net benefits to customers, then in that context, a financial incentive would not necessarily be a harm to customers.
But wouldn't it, you also answered my question that it'd be more beneficial for there to be no financial incentive, and you answered that affirmatively. So why is it that adding if it is the case that adding the financial incentive makes customers worse off, how do you parse out that not being a harm in your expert opinion?
I'm going to object. I believe these hypotheticals, my memory is not completely great, but I think a lot of this was answered on Mr. Du Bois' cross-examination previously. And as Mr. Higgins indicated himself, he's answered the question a few times already. So asked and answered.
Mr. Du Bois.
Your Honor, respectfully, it has been asked. It has still not been answered. This is a yes or no question. No yes or no has been given. And I'm having a very difficult time having an efficient cross-examination where an expert witness indicates that he's unable, and his counsel indicates he's unable to answer hypothetical questions. As far as I know, experts are supposed to be able to answer hypotheticals that were within the scope of their testimony.
Well, and I'm going to make a ruling not based on, I mean, I think the witness has answered the hypothetical In his last answer to you, Ms. Gonzalez, can you read back Mr. Higgins' last answer to the question?
Sure. Give me 1 second. So here's the question that I have, and then I'll read the answer. So isn't the financial incentive there a harm to customers by reducing the benefit? Answer: I believe I've answered your question, Mr. Dubois. I said if the financial incentive was incorporated into a larger proposal that provided net benefits to customers, then in that context, a financial incentive would not necessarily be a harm to customers.
I think the question's been answered, Mr. Du Bois. Move on. I'm going to sustain the objection.
Doesn't SPS's proposal, concrete proposal in this case, provide a net benefit to customers because the cost of the energy it is using to meet and exceed the renewable portfolio standard is substantially below the reasonable cost threshold?
I do not believe that I'm sorry, I want to answer your question, Mr. Boyce, so if you wouldn't mind asking it one more time. I want to make sure I answer the question you're asking.
Doesn't SPS's proposal in this case provide net benefits to customers, given that the costs of the energy proposed to be used and the RECs proposed to be required to exceed the annual standard have a cost that is substantially below what you agreed to be the legislature's valuation of $60 as the reasonable cost threshold?
No, I do not believe the company's proposal provides net benefits to customers. I agree that that the energy that the cost of energy that the company incurs to produce its renewable power is less than, on average, the reasonable cost threshold, which speaks to the larger question of the company's program and the reasonableness of the company's program. But I do not believe that the company's proposal in this case to be paid a financial incentive is beneficial to customers.
And I won't ask you again whether customers are disadvantaged if RECs are retired early, but how if I ask, are customers disadvantaged if RECs are allowed to expire unused?
I would say that the expiration of RECs unused would be an unfortunate consequence for customers, in my opinion.
And the legislature said that that unfortunate consequence is okay, correct?
Legislature said that the company would not be have costs disallowed as a consequence of that.
Was that an agreement with my question?
Well, you used the word okay, and I don't know that I read into the statute that it's okay to allow the RECs to expire unused, but I do agree that the statute says that if that were to occur, the company would not be penalized through the disallowance of costs.
Can you explain to me the difference between those two things, Mr. Higgins?
I think we're going back, Mr. Du Bois, to the notion, to the concept of whether the statute endorses such an action. And I'm simply saying, I'm looking at the plain language, and I agree that the utility would not be penalized or subject to a disallowance if the recs were allowed to expire. And you want me to parse out whether I believe that means it's okay. I don't know that something that doesn't call for penalty is necessarily also equivalent to something being okay. But I agree that it doesn't rise to the level of being penalized.
But you would agree that a utility could not be penalized, even though, in your opinion, customers would be disadvantaged by the same action. Correct?
Correct.
Okay. Thank you, Mr. Higgins. Thank you, Your Honor.
Anything further for Mr. Higgins? Seeing nothing. Mr. Higgins, thank you, sir. You are excused.
Thank you, Your Honor.
Mr. Rushoff, anything further?
Nothing further from the NMLCG.
Very well. Mr. McMillan or Ms. Coleman, you have a witness.
Yes, Your Honor. OPL has Jeff Pollock, who should be in the waiting room. I believe he was listening on YouTube.
Not yet.
I will text him, one moment.
Okay.
Okay, he should be on the way, Your Honor.
Okay.
Okay, he says that he is in the waiting room.
There he is. There you are, Mr. Pollock. Good afternoon. You just need to unmute yourself. There you go.
I get that all the time.
Yeah, so do I. Go ahead, Mr. McMillan.
Good afternoon, Mr. Pollock. Could you introduce yourself, please?
Yes, I'm Jeffrey Pollock.
Hold on, let me swear him in.
Oh,
Do you,
yes.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Thank you.
My sound coming through okay?
Yes.
Okay, good.
Okay, Mr. Pollock, could you introduce yourself, please?
I'm Jeffrey Pollock.
Do you have a copy of OPL Exhibit 1, which is your direct testimony?
I do.
Do you have any changes that you'd like to make to that testimony?
No.
If I asked you the questions written in that testimony, would your answers be the same today?
Yes.
Your Honor, OPL offers OPL Exhibit 1.
Mr. Pollock, are the answers true and correct to the best of your knowledge?
Yes, they are.
And did you prepare, or was your appendix prepared under your direction and control?
Yes.
Okay. Any objection to what's been identified by and verified here today by Mr. Pollock, his direct testimony offered in this case? Hearing no objection, Occidental Exhibit 1 is admitted. Mr.
Your
McMillan?
Honor, yes, Your Honor. OPL offers Mr. Pollock for cross-examination.
Very well. Mr. Du Bois or Ms. Lees, you have questions for Mr. Pollock?
Yes, Your Honor, that's me again.
Okay, go ahead, sir.
Thank you, Your Honor. Good afternoon, Mr. Pollock.
Good afternoon.
Were you following along to the questions I had for Mr. Higgins?
I was trying to follow along, yes.
Okay. Just checking to see how efficient I think we can be. We'll just have to figure it out as we go along. And of course, if you're unable to hear a question or you don't understand, please do flag me and we'll figure it out from there.
Okay, likewise.
Thank you. Is it your opinion that the way to demonstrate an exceedance of the annual renewable portfolio standard to be able to show an exceedance of the RPS to earn an incentive would be to turn in or retire renewable energy credits in excess of the annual standard?
So that would certainly be a necessary requirement, right? Because unless you had excess RECs, you wouldn't be exceeding the standard. Now, whether or not that situation warrants a financial incentive, I think is a different and more nuanced question.
Do you think it could be the incentive could be earned without retiring renewable energy credits in excess of an annual standard?
I'm not opining on that, no.
I'm sorry, is the answer to my question no, or you don't have an opinion on it?
I don't have an opinion on it.
So hypothetically, if a utility had a generation mix where under that generation mix, its renewables exceeded the annual standard, but it didn't actually retire renewable energy credits in a year in excess of the standard, could that utility potentially earn an incentive if your other criteria are met?
I think it would depend upon whether the excess RECs were the result of the procurement of additional renewable resources after the date that the rule was enacted.
Sorry, either I asked the question wrong or you misunderstood the hypothetical, Mr. Pollock. Let me try again. Let's assume, I think, two things for the hypothetical. First, the utility in question has a generation mix with renewables in excess of those needed to meet the annual standard. You have that?
Yes.
And second, that utility only retires enough RECs to meet the standard in the year and does not retire any RECs beyond the exact number required to meet the standard in that year. Do you have the second assumption?
Yes.
My question is, could that utility potentially earn an incentive if it met the other criteria you have.
Not unless the RECs that are being retired are associated with the procurement of new renewable resources that occurred on or after the date that the rule was enacted.
So is it your answer that if a utility were generating RECs in that year that did not exceed the standard, but those RECs were generated from new resources, that utility would be eligible for an incentive?
If the new resources were in place after the date the rule was enacted, and despite that, the utility did not exceed the RPS standard, then I think the utility would not be entitled to a financial incentive. I think both circumstances have to occur to warrant a financial incentive or consideration of a financial incentive.
When you say both circumstances, is one of those circumstances retiring renewable energy credits in excess of the annual portfolio standard for that year?
It's the existence of renewable energy credits in excess of the requirement. That's the first standard, and the second standard is that those RECs that are going to be retired are associated with resources acquired after the date that the rule was enacted.
So the utility would have to have RECs that would allow an exceedance of the standard, but doesn't have to retire RECs in exceedance of the standard. Is that what you're testifying to?
No, I'm not saying what the utility has to do with the RECs that are in excess of the retirement. I'm opining on under what circumstances with retiring of those RECs warrant consideration of a financial incentive.
Mr. Pollack, I think you're overcomplicating my question. It is very simply just, would a utility have to retire RECs in a given year that exceed what it needs to meet the renewable portfolio standard in that year in order to potentially, with whatever other criteria you want to put on, be eligible for an incentive?
Well, it's a necessary condition, but it's not a sufficient one.
Okay, I think that's a yes, correct?
It's a nuanced, yes, that's part of the test, but it's not the entire story.
Well, I thought I was carving out meeting other criteria you had. Or do you think there are things other than meeting other criteria that would have to be added?
I think when it comes to a financial incentive, I think they have to meet the two criteria that I've enumerated.
And one of those criteria is...
Move on, Mr. DuBois. He's answered the question 3 times already. Move on to your next question, please.
Mr. Pollack, do you agree that the energy associated with renewable energy credits is beneficial to customers in New Mexico?
You mean as a general proposition, or because it was the path that SPS chose?
As a general proposition, would you agree that, generally speaking, renewable energy associated with renewable energy credits is beneficial to New Mexico customers first?
I think it would depend upon the costs of implementing the renewable energy purchase as compared to the projected benefits. And if it did that, then I would agree that it would be beneficial if you can demonstrate that the benefits outweigh the costs.
So that renewable energy may have no benefit whatsoever.
It may have a benefit, but benefit may not exceed the cost.
I didn't ask you for a cost-benefit analysis in this question, Mr. Pollack. My question was simply, does, as a general proposition, renewable energy associated with a renewable energy credit have associated with benefits?
It has associated benefits.
Thank you. And it has associated benefits for New Mexico customers, correct?
It certainly has that potential, yes.
potential, or it in fact is beneficial?
I think it has to be demonstrated that the benefits outweigh the costs.
When a utility meets the annual standard with generation that on average falls beneath the reasonable cost threshold, is that energy beneficial to customers?
Not in and of itself, no.
So the legislature may be calling for customers to be harmed by requiring utilities to procure or acquire renewable energy that exceeds the value that you think it has to customers, correct?
I don't know what the legislature thinks. My view is that the commission has the overall authority to make sure that any resource procurement will result in benefits that outweigh the costs.
So it is your opinion that the commission could, instead of allowing the $60 reasonable cost threshold, make the reasonable cost threshold $25 because that's its opinion as to the value of renewable energy, correct?
I don't associate the two things. The reasonable cost threshold is my understanding is that provides a somewhat of a circuit breaker that determines whether or not you should proceed with an acquisition that exceeds that level and do so with some caution.
Well, the legislature has said that a utility can procure renewable energy that exceeds the reasonable cost threshold, correct?
The legislature, there's no, my understanding is it doesn't say you can't do it, but there are requirements. If you're going to do it, you have to meet those requirements. And you have to be able to show, you have to be able to demonstrate to the commission that it's a benefit to spend more than $60 or whatever the number happens to be in a given year. And if the utility can demonstrate that and show that there are no lower cost options available to meet the standard, then commission can deem that approved.
Can you show me where those conditions are found, Mr. Pollack?
The conditions being what?
Well, didn't you just say?
Yeah. You mean the conditions under which the commission would make a determination? It would make a determination in a resource planning case, just like it did for Hale and Sagamore and the two solar PPAs.
Didn't you just testify that a utility acquiring renewable energy with a cost in excess of the reasonable cost threshold would have to meet conditions in order to do so?
That's my opinion, yes.
And where in the statute and regulation do you draw that opinion from?
It's my opinion that's drawn from the fact that the commission has an overarching responsibility to make sure that rates that are set that include all of the resources and costs incurred by the utility are just and reasonable. And the commission would be carrying out that responsibility by examining in a case, in contested proceeding, whether or not the cost of a particular resource is worth the benefit.
Now, you did review New Mexico Code 62-16-4 in preparing your opinions in this case, correct?
You have to be a little more generic.
Have you reviewed New Mexico Annotated Code section 62-16-4?
If that's the Renewable Energy Act, yes, or Energy Transition Act, yes, I've reviewed those.
Are you aware that the Renewable Energy Act and the Energy Transition Act are not exactly the same thing?
I really don't have a view of that.
Okay, if you could please refer to New Mexico Code section 62-16-4E for a moment. And I think Your Honor may be going there as we speak.
Okay, I'm just having a little hard time getting my screen adjusted so I can actually see it. Oh, goodness. Okay, this is a little harder. There we go. Okay, I got it. Okay, go ahead.
Have you reviewed this subsection before?
I'm certain that I have at some point.
Did you rely on it in forming your opinions in this case?
Well, since I'm not an attorney, I can't rely on my non-legal interpretation of the statute, so no.
Didn't you interpret the statute and the rule in providing your testimony in this case?
No, I didn't. I provided my opinion based on my regulatory understanding of the applicable rules and my overall understanding of regulation.
You did cite legal provisions in your testimony, correct?
I know I cited to the reasonable cost threshold because it appeared that that's the anchor in which the company was assuming that the financial incentive would be appropriate.
So did you rely on any interpretation or understanding of subsection E here in forming your opinions in this case or not?
Not specifically, other than the fact that it's not, the reasonable cost threshold is not relevant or germane to the issue of whether the benefits exceed the costs.
Would you please identify for us your opinion as to what are the quantifiable benefits associated with renewable energy tied to a renewable energy credit?
Well, in terms of the rule, one of the quantifiable benefits is the effect of reducing carbon dioxide emissions. That seems to be one that's consistent with the overall goal of moving toward more renewable generation mix.
So that's one benefit. Can you identify any other benefits?
I'm certain there could be other benefits. There could be other costs too.
Can you name another benefit, please?
It's possible that a renewable resource could provide the necessary capacity to allow the utility to maintain a reliable system under certain circumstances. That's certainly a benefit. And it's a benefit that could be quantified too.
Okay. Can you identify a third benefit?
Not one that isn't overlapping the first two.
Okay. Can you identify a cost associated with renewable energy associated with the renewable energy credit?
Sure. The levelized revenue requirement, as the company has done, is certainly a reasonable effort to quantify the cost to achieve or overachieve, the RPS standard. There could be other costs. I've identified one other cost to the extent that the company carries out its plan to retire the RECs early and has to accelerate procurement of additional renewable resources. There is a time value of money cost associated with moving a resource plan forward. There could also be costs associated with early retirement of existing resources. Those are costs that, and I don't discuss those in my testimony, but those are certainly costs that I think would have to be considered in order to justify overachieving the standard.
Would you agree that a utility could retire RECs in excess of the annual standard without earning an incentive for it?
I think the utility can decide what it wants to retire in terms of RECs unless there are previous limitations of doing so as required by a CCN or other commission rule. For example, a utility could sell those RECs.
Would you agree that a utility could retire RECs in excess of the annual standard without earning an incentive and receive associated with cost recovery from customers?
Well, if the end result of that is to put the utility out of compliance, I don't know that that's a desired strategy or outcome for the customers.
Are you aware that under the Renewable Energy Act, a utility can allow renewable energy credits to simply expire without being penalized?
That I understand that language. You went over that with Mr. Higgins. I'm not sure why a utility would ever do that. If you can sell them before they expire, at least you get some value that customers could benefit from.
Do you have an opinion as to whom in New Mexico the Southwestern Public Service Company could sell renewable energy credits under current law?
I don't know. RECs are pretty fungible.
Are you aware that under the Renewable Energy Act, RECs have to, if they are sold, be sold with the energy they are tied to for the use by end use customers?
I don't know that.
Okay. Do you know why the legislature would provide that a utility can allow RECs to simply expire without penalty?
Objection, Your Honor. Speculation and calls for a legal opinion.
Mr. Du Bois?
Your Honor, if we don't have speculation as to the intent of the law in this testimony, I'm not sure what exactly we have.
Your Honor, anything that Mr. Pollack says about why the legislature, what the legislature thought they were doing when they passed that provision of the REA is just going to be, Mr. Pollack's, unsupported opinion. He's not a legislator. He wasn't there.
Mr. Du Bois?
If that is Occidental Permian Limited's position, I would ask for a moment to go back through his testimony and see what I would request to strike that is related to interpretation. And if Occidental Permian would agree to that, I'll withdraw the question.
Would agree to what?
Strike the portions of Mr. Pollack's testimony that provide or imply conclusions as to the legislative intent and purpose.
Your Honor, I would not agree to that up front, especially without knowing the specific portions that Mr. Du Bois is proposing to strike.
Well, and I'll just shortcut it. I'm going to overrule the objection. Mr. Pollack, answer the question if you know.
Please give me the question again, please.
It had something to do with, do you know what the legislature thought? Mr. Du Bois, what was your question?
Mr. Pollack, can you offer any rationale for why the legislature would have provided that a utility can simply allow renewable energy credits to expire unused without penalty?
I can offer an opinion. That opinion would be that legislature didn't want to penalize a utility that overcomplied and maybe overcomplied a little too much, and as a result ended up having to let some renewable certificates expire.
And hold on just a second, Mr. Pollack. Mr. Du Bois, I want to know specifically what section you're referring to, because I keep hearing this without penalty, and I keep hearing the witness say, it doesn't say without penalty. It says something about the cost recovery. So why don't you refer me to the section you're talking about, Mr. Du Bois?
Well, Your Honor, I'm referring to the sentence that we have been talking about at the end of subsection E that states when a public utility can generate or procure renewable energy at or below the reasonable cost threshold It shall be required to do so to the extent necessary to meet the applicable renewable portfolio standard. Oops, I'm in the wrong section, Your Honor.
Yep.
Meant to be down in 5, Your Honor. 5B2. The Commission shall not disallow the recovery of the cost associated with any expired renewable energy certificate. And I'll represent the without penalty language was what Mr. Higgins had offered to me in response to my questions. And I continued using that, and I've continued using that language with Mr. Pollack, who has not disagreed with it either.
Oh, he has disagreed with it. And I think the transcript will show that, Mr. Du Bois.
If I may, then, Your Honor, can I ask Mr. Pollack what penalty the utility would be subject to for allowing the renewable energy credit to expire?
Mr. Pollack, you see the section that we're referring to?
Yes.
Have you specifically said that, have you referred to that section as being a penalty?
I don't think I've referenced that section at all in my testimony.
Okay.
If I have, if somebody needs to show me where I reference.
And in response to Mr. Du Bois' questions about expiration of renewable energy certificates, have you referred to this section as a penalty, or have you testified that it is a cost recovery issue, or have you testified in response to his questions anything?
Your Honor, I don't recall referring to the section of the statute in my testimony at all.
Okay, and we're talking about his questions to you here today.
Right.
Okay.
So it's kind of an on the stand, quick opinion, obviously
Okay.
not from a lawyer.
Okay. So his question to you then is, whether or not, now I've forgotten it, Mr. Du Bois, it's something about a penalty. So go ahead and ask your question again.
Yes, Your Honor. My most recent question is whether Mr. Pollack is aware of or can think of any way in which a utility could be penalized for allowing a renewable energy certificate, I think we've all been calling it credit, but a renewable energy certificate to expire.
And my answer is, at least reading just that section of statute, it suggests that the Commission couldn't outright disallow the cost of letting a REC expire. However, the Commission has broad authority over SPS, and they could exact their wrath in other ways.
Would that wrath constitute a penalty?
I don't know.
Could the Commission levy a civil penalty against a utility for allowing a REC to expire?
I don't know.
Did you review this subsection in preparing your testimony and your opinions in this case?
No, I said I did not.
Do you think the Renewable Energy Act's provisions are relevant to the matters you are testifying about in this case?
Certainly.
Change gears, Mr. Pollack, and if you could please refer to page 9 of your testimony.
Okay, page 9.
Let's start with the first 2 lines there and the sentence beginning, however. Do you see that?
Yes.
And is it a fair characterization that, in your opinion, resources procured or built with a decision date prior to the effective date of Rule 572's incentive provision cannot be counted toward exceeding the RPS for the purpose of earning an incentive?
Yes, that is my position. Yes.
Are you aware that there was an incentive provision in the Renewable Energy Act before Rule 572's incentive provision was adopted
Yes.
by the Commission?
I'm sorry. Yes, I was aware.
And are you aware that there was an incentive provision in the Renewable Energy Act before the Energy Transition Act was passed?
Yes.
Is it your opinion that portions of the Renewable Energy Act are only applicable to the extent the Commission has adopted them in Rule 572?
I think to a large extent, that's a legal interpretation, but I think the Commission can certainly set the rules for determining, in this instance, quantifying a specific financial incentive as opposed to providing a generalized incentive through the rate-making process.
Isn't it a legal conclusion for you to state in your testimony that a renewable resource can only be used toward earning an incentive under the law if it was procured or acquired pursuant to action taken after the adoption of Rule 572's incentive provision?
I'm interpreting, it's my understanding of the rule. I'm not interpreting the law. I'm interpreting what the rule was and what the elements that the Commission considered in drafting that rule.
Is interpreting a regulation, in your view, not a legal interpretation?
There's obviously legal elements of it, so I'm obviously giving you my non-legal interpretation.
Isn't the question of when a statute is effective a matter of law outside of a regulation?
Objection, Your Honor. Relevance as to Mr. Pollack's opinion about the scope of legal opinions and what constitutes a legal opinion. I mean, he's an expert witness who's allowed to give his opinions on what statutes or how statutes are effective in the regulatory sphere, and that's what he's done here.
Mr. Du Bois?
Your Honor, Mr. Pollack is in this line of questions declining to answer questions regarding the statute on the basis that he's not a lawyer, but has testified and is continuing to testify on matters in the regulation, including where he acknowledged that there is legal interpretation involved in that. And I would submit that the question of when a statute applies to the Commission and a utility, which he has testified about, is a legal matter. So I'm trying to parse out where his line is between legal matters he will testify to and legal matters he will not testify to.
Then I think you need to make a more specific question, Mr. Du Bois. I think you are exceeding the scope by asking him about all statutes. I think you need to confine your questions to any type of regulatory rule or statute. So I'm going to sustain the objection and you can rephrase your question.
Mr. Pollack, it is your testimony that a utility that took actions to procure or acquire renewables prior to the effective date of Rule 572's incentive provision is ineligible for an incentive by New Mexico law, correct?
I'm not saying that at all. I'm saying that the incentive has kind of evolved over time and it's such that now, according to the rule in subsection 527.22, The financial incentive is now a very specific thing that can be demonstrated and shown in a contested proceeding.
Well,
that's the difference between now and before the rule came into effect.
So on page 9, lines 6 to 8 of your testimony, you stated that SPS is not eligible for financial incentive because the actions taken that resulted in early compliance with the 2025 RPS requirement predated the effective date of the Energy Transition Act and the financial incentives now incorporated in Rule 572. Do you see or recall that?
Yes, I do.
Is that your opinion of what New Mexico law provides?
It's my reading of the rule that I just quoted. It says actions taken. It says measures implemented on or after the effective date of the rule.
And it's your opinion interpreting the rule irrespective of what the statute says, correct?
Well, I'm interpreting the commission's rule. I'm not
Are
going to opine on whether the rule is consistent or not with the statute. That's for the lawyers to determine.
Can I have one moment, Your Honor? I think
Sure.
we may be able to knock out some questions. Mr. Pollack, could you please go back to page 6 of your testimony at lines 16 to 20?
Page 6?
Yes, sir.
Hold on, please. Okay.
Line 16 to 20?
Okay.
Do I understand correctly, based on your statement there, that it is your opinion that if a utility has an opportunity to sell renewable energy certificates rather than to retire them to exceed the annual standard, it has an obligation to do so?
I didn't say it was an obligation. I said they have an option. You obviously have to look at the circumstances at the time a decision is made. Is it better to hold on to a bank and risk having the certificates expire without value, or is it better to try to monetize them because customers want them and are willing to pay for them?
Well, to be clear, Mr. Pollack, the either or I'm asking you about here is an either or between selling RECs or retiring them for the purpose of exceeding the annual requirement.
Sure, if that's an option. Yes, if that's an option, yes. So if that is an option, then the logical thing to do would be to determine what the financial impact of retiring the RECs early and decide what that impact is vis-a-vis selling or some other alternative that I haven't thought about. But in either way, it triggers an analysis to say which is the best option.
Mr. Pollack, Your Honor, I'll stop there. Thank you.
Thank you. Mr. Rushoff, any questions?
Hello, no questions. Thank you.
Okay. Ms. Lynch, any questions?
No hearing examiner.
Okay. Ms. Drake?
No questions, thank you.
Mr. Bagatko?
Madam Hearing Examiner, no questions for Mr. Pollack, but we thank him for his participation today.
Good afternoon, Mr. Pollack.
Hello, Butch Hurst. How are you?
I am okay.
Good.
Yourself? Still
Excellent.
doing okay? You're smiling? That's good. My understanding is that Occidental participated in the rulemaking.
Yes.
In case number 19-00296, in the matter of potential amendments to the renewable energy for electric utilities. Is that correct?
Yes, it is.
And did you personally participate on behalf of Occidental in that docket?
I was asked to review some of the draft comments and offer opinions.
Okay. And did you?
I did.
Okay. So one of the questions that Mr. Du Bois just asked you about monetizing RECs. Are you familiar with the requirement that has been mentioned here today? Have you been listening today?
I have.
That there's a requirement, I think, in the statute that says that in New Mexico, that if the renewable resource is generated here, then the RECs have to be used on behalf of the customers of that public utility.
I'm not familiar with that level of detail now.
Okay. But if that was the case, that might affect, do you believe that might affect your options for New Mexico public utilities?
It certainly would limit the options somewhat, yes. But you still need to look at all the options, for making a decision.
Okay. Mr. Pollack, you specifically and Occidental have participated in several of the cases before the commission. Are you aware of the commission granting any financial incentives for renewables at any time, whether it's prior to May 4th of this year or prior to the Energy Transition Act here in New Mexico?
I don't, other than May the 4th be with you. I really don't have an understanding of that. But there are different, as I said, I think in earlier responses to questions, not to be flippant. But there are a lot of different ways that you can send, financial incentives to utilities besides just simply a number that you then add to a cost recovery clause. And one I would cite specifically is the fact that you have a separate cost recovery clause that allows for timely cost recovery and reconciliation of past balances. That a lot of utilities would view that as a financial incentive, even if it doesn't necessarily boost their earned return on equity. It does give them more timely cost recovery, and that lowers the risk, which in turn lowers the cost of equity. So there are different ways to skin the cat, as I would say.
Yeah, we used to say that, but now it sounds really icky.
I'm sorry.
I don't know. I don't know if it's too many of those awful commercials with the poor animals.
Yes, I agree, and I'll try to come up with a better analogy for next time.
But no, we used to say that. A
lot of things we used to say we don't say anymore.
Well, that's true too. Yeah, there you go. Do you have an explanation, since you were familiar with the rulemaking docket? One of the things that SPS has pointed out is that this whole cost section in D, as in dog, of quantifying the carbon emissions, mm-hmm. and the fact that it seems to be mandatory to make this calculation. Mm-hmm. Do you find that troubling?
You mean the fact that you have to actually do a cost benefit analysis?
In terms of carbon dioxide emissions, even if you're not claiming that standard?
Yeah, I don't know. I think you just have to find a suitable way to quantify the costs and benefits in a way that doesn't, create a lot of overlapping things. Carbon dioxide benefits obviously are pretty significant, and SPS has certainly attempted to quantify them. There could be other ways to do the benefit that doesn't look at necessarily CO2, like how about the lower overall rates over the long term. Maybe that's a financial benefit.
So it doesn't necessarily give you heartburn that even though their request is under B as in bay, they're making their request under B1, i.e. exceeding the public utilities annual RPS, and not under 2, reducing carbon dioxide emissions.
Right.
But yet, subsection D as in dog says, and to establish this, the utility must provide detailed analysis for each applicable period, including but not limited to, and then that's all about carbon dioxide.
It is. That's it almost suggests that you'd be a safe bet to do an analysis based on carbon dioxide benefits, and maybe do something else that would be icing on the cake to help prove your point.
Or do you think that they think everybody's just going to try to get an incentive on 2?
Well, I mean, that would require taking some action that is not even the subject of this case, right? They haven't.
No, and I understand that. But like I say, I just, I mean, there's some sympathy with, I mean, if you follow through with SPS's position that they're not, that the reason, the basis for, behind their request is, hey, we're exceeding.
We're exceeding the standard. Yeah,
right.
I get it. Yeah.
So they're not saying, oh, and we're reducing carbon dioxide emissions.
The question, the thing I think that puts all three things together is that what actions have they taken since the rule was implemented to accomplish any of these three objectives? I mean, I don't want to boil it down to being too simple, but it just, in my simple mind, that's, show me you've done something. I'm from Missouri, so you have to show me.
Well, and you realize that the, I'm not SPS's advocate, but
No,
but you understand SPS position in this case is, well, we will be, because we're asking to, our action will be that we're going to, if you give us the incentive, or we will now retire after the effective date of the rule, these banked recs.
Right. And of course, that action, as they say, every action has a equal and opposite reaction, right? So, by the way, we're going to have to put in a bunch of new renewables much sooner than we thought. Oh, what does that cost? Well, I don't know. Yeah. That's the problem. If we knew what that is, then we could understand, what are we trading off?
Yeah. Okay. All right, Mr. Pollock. That's all the questions I had for you. Mr. McMillan, any redirect for your witness?
No redirect, Your Honor.
Very well. Mr. Du Bois, are you sufficiently questioned today?
Yes, Your Honor. Thank you.
Okay.
Say yes. Well, say yes.
Anything further? Hearing nothing. Mr. Pollock, thank you. You're excused, sir.
Thank you, Judge Hurst. Appreciate it, as always.
Thank you. Mr. McMillan, anything further from Occidental?
Nothing further from OPL.
Okay, very well. I believe that leaves us with one witness. And I believe Mr. Bagatko, staff has a witness.
That's correct, Madam Hearing Examiner. And I would call Ms. Leyva Tesoro to the stand. I know she's been watching on YouTube, and you should probably see her in the waiting room momentarily.
Okay. So are we finding the screen sharing helpful?
Yes.
Yes, Your Honor, especially since not every witness has had things accessible. I think it's been very helpful.
There she is. Hello there, Ms. Leyva Tercero.
Hello.
Who looks like not a white screen, so I don't think you must be in the building.
I am not.
Yeah, okay. I think Ms. Gonzalez, if you could swear in Ms. Leyva Tercero, please.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Thank you.
Thank you. Mr. Bagatko.
Thank you. Good afternoon, Ms. Leyva Tesoro. How are you?
Good afternoon. I'm doing well. How are you?
I am fine. I trust and hope that you have a copy of what's been provisionally marked as Staff Exhibit 1 in front of you.
Yes, I do.
And I would warrant you that that is the same Staff Exhibit 1 that was previously circulated to the hearing examiner and all the parties last Friday. Does that meet with your recollection?
Yes.
And is it correct that Staff Exhibit 1 consists of your direct testimony that was filed in this case on September 2nd, 2021?
Yes.
Ms. Leyva Tesoro, if you take a moment to please flip through that PDF copy of your September 2nd, 2021 direct testimony to make sure that it is complete and accurate.
Yes, it is.
And can I take it as true that this testimony was prepared by you or at your direction?
Yes.
And that would be inclusive of your exhibit ELT1, which consists, I understand, of the your case history. Is that correct, Ms. Leyva Tesoro?
Yes, that's correct.
And is it also correct that you don't have any changes or corrections to make to your direct testimony as we sit here right now?
That's correct. I do not have any changes.
And if you were asked the same questions today at this public hearing as what we see posed in your direct testimony, would your answers to those questions still be the same?
Yes, they would.
All right, with that, Madam Hearing Examiner, I would move for admission of the direct testimony of Alicia C. Leyva Tercero into evidence as Staff Exhibit 1.
Any objection to what's been identified as Ms. Leyva Tercero's direct testimony is verified by her here today? Hearing no objection, Staff Exhibit 1 is admitted.
And if it pleases you, Madam Hearing Examiner, I would tender Ms. Leyva Tercero for cross-examination.
Very well, Mr. Bagatko. Ms. Lees or Mr. Du Bois, any questions for Ms. Leyva Tercero?
Your Honor, I should clarify that I was questioned out as to Mr. Pollack. I do have some very brief questions for Ms. Leyva Tercero.
Very well. Go ahead, sir.
Thank you, Your Honor. Good afternoon, Ms. Leyva Tercero. I don't know if you've been listening, but I'll say as I did to the other witnesses, if you're unable to hear me or if my question doesn't make sense to you, please jump in and we will see if I can either rephrase or make sure you've heard the question. Does that make sense?
Yes, thank you. And I can't see you right now. Let me see if I can change my view. There we go. Okay, I'm sorry.
No problem. Let me ask first, do I read your testimony correctly that you've offered some opinions as to how you believe SPS's proposal for an incentive fits under Rule 572, but do not offer an opinion as to the Renewable Energy Act provisions themselves?
That's correct, but I read the rule with the statute.
Okay. Did you review the reasonable cost threshold provision of the statute in preparing your testimony?
Yes.
Okay. And just for clarity's sake, that is New Mexico Code Section 62-16-4, subsection E, correct?
Yes.
Okay. And under this subsection, would you agree that the legislature, by requiring that renewable energy be acquired up to the $60, approximate $60 threshold? I'm sorry, I'll start that question over. It was going to get unclear. Would you agree that when the legislature set a reasonable cost threshold pursuant to which a utility would be required to continue acquiring renewable energy up to at least a cost of $60, it was determining that there would be benefits associated with that renewable energy that would at least offset that cost up to $60?
I believe that would be a reasonable assumption.
Okay. And just as an example, if a utility was going to incur a cost of $59 to acquire the energy that it needed to finish meeting the renewable portfolio standard for a year, it would not be the case that, in the legislature's view, that cost of $59 would exceed the benefits of that renewable energy, correct?
Well, I think there could be situations where there are other resource options available that could be below that price.
But as a general matter, would you agree that the legislature wouldn't be in the position of requiring utility to continue acquiring up to that $59 level if, for example, the benefits from renewable energy were actually only $20?
Yes.
Okay. Thank you, Ms. Leyva-Tercero. Thank you, Your Honor. That's all I have.
Thank you.
Mr. Rushoff, any questions?
No questions.
Mr. McMillan?
No questions, Your Honor.
Ms. Lynch?
No questions, Your Honor. Thank you.
Thank you. Ms. Drake?
No questions from me. Thank you, ma'am.
Okay. Good afternoon, Ms. Leyva-Tercero. I have a few questions for you. And as the only staff witness, you had a lot to do in this case. And there is a lot more in SPS's application than just its request for incentive, correct?
Correct.
And your testimony goes through all of SPS's requests, all 8 of them, as you have set them forth on pages 2 and 3 of your testimony, correct?
I believe so, with the exception of SPS's request for a variance from the cost benefit analysis, and that is because my position was that SPS did not qualify for an incentive, so then there wasn't a need to get into that analysis.
Okay, and I'm just asking you, you've laid out what SPS has wanted in your pages 2 and 3 of your testimony?
Yes, I did.
Okay. And part of that is a review of the results of their 2020 RPS report, correct?
Correct.
And you testify on page 3 of your testimony that SPS did in fact comply with the RPS requirement for 2020, correct?
Correct.
And additionally, in reviewing that report, you found on page 4 of your testimony that SPS did in fact satisfy the reporting requirements that were set forth under Rule 572 and the REA, correct?
Correct.
Further, in that particular report, there were some reporting requirements based on prior commission cases, correct?
Yes.
And you set forth the information that SPS provided in pages 5 and 6 of your testimony, correct?
Correct.
Then the next part of your testimony, pages 6 through the beginning of page 9, you're testifying to recent requirements, standards that relate to renewable energy and include amendments to the Renewable Energy Act and the Commission's Rule 572, correct?
Yes.
And then beginning on page 9, then you start to give your review and testimony on SPS's actual 2022 RPS plan as it was filed in this case, correct?
Yes.
And on page 11 of your testimony, you testify that SPS's existing renewable resources are sufficient to meet the 2022 plan year and 2023 next plan year RPS requirements, correct?
Yes.
And then you set forth at pages 11 and 12 how they're going to satisfy those plan and next plan year requirements, correct?
Correct.
And none of those, well, that's not what I want to ask. SPS has not proposed any new renewable resources for the commission to approve in this plan, correct?
That's correct.
Okay. And then on page 12 of your testimony, you begin your testimony and review of the cost recovery for the 2022 and 2023 riders, correct?
Yes, that's correct.
Okay. And you're in agreement, aren't you, Ms. Leyva-Tercero, for example, with the chart and the numbers on page 14 of your testimony about the cost and recovery mechanisms and the actual revenue requirements that SPS has put forth in its application?
Yes, I am. They're consistent with prior commission approvals with the rule and the statute.
Okay. And on page 14, the question posed at line 6, what is SPS's total proposed 2022 RPS rider revenue requirement? And beginning on line 7, you say the total 2022 RPS rider revenue requirement is $19,479,566.94. This amount includes rider costs in the amount of $15,526,069.62 and an RPS reconciliation in the amount of $3,468,715.72 and interest in the negative amount of $10,117.51. Correct?
Yes.
How can interest be in a negative amount?
I believe SPS would have had to over recover on its interest in prior years. And so now they're reconciling that amount. And I know that the interest that they're using, the customer deposit rate, has decreased. That rate has decreased.
And the interest that they're referring to is that the weighted average cost of capital amount?
No, that's the customer deposit rate.
Oh, so if I recall correctly, in the rate case, I heard that's a little over 1% now.
I believe so.
It's posted on the commission's website. It's the customer deposit rate.
Yes.
Okay. And on page 15 of your testimony, Ms. Leva-Tercero, you discussed the reconciliation rider, correct?
Yes, I do.
And you testify beginning at line 13 that this was approved in case number 19-00134 to return or recover costs associated with time periods prior to the elimination of the large customer cap, correct?
Yes.
How long is it going to take to get this collected?
I would think that it should be done pretty soon, but that would be a better question for SPS.
Okay, I just wanted, I mean, there is a finite time period, correct?
Yes.
When, they're going to, end this transition away from the large customer cap cost, right?
Yes.
Okay, but you don't know when that is? Is it going to be in our lifetime?
Yes, I think it should be very soon, maybe in the next case.
Okay. And ultimately, on page 17 of your testimony at line 17, you testify, Ms. Leva-Tercero, that staff does not contest the cost components of the rider, the revenue requirement, the calculation, or the reconciliation. Correct?
Yes.
Then you spend the next section talking about the Solar Connect, its relationship from case number 18-00308. And ultimately, on page 19 at line 16, you recommend that the commission approve the rate, the Solar Connect community rate to the extent it's able to, because it just began in April of 2021, correct?
Yes.
And then it isn't till, and so pretty much that concludes with staff in agreement to all of SPS's requests that SPS has complied, and the commission should approve all of those requests except for the incentive, the rider, and you don't give any opinion on the variance. Is that correct?
Yes, because my position is that SPS does not qualify for the incentives, and it makes the variance request unnecessary.
Okay. And in fact, staff recommends that that SPS's request recommends to the commission that SPS's request for an incentive under 572 be rejected, correct?
Yes, that's correct.
And primarily, well, maybe I shouldn't say primarily. On page 23 of your testimony, at lines 1, you start out with, while I'm not an attorney, correct?
Yes, I do.
I interpret the emphasized language in the above section of Rule 572 to mean SPS can only earn an incentive for exceeding its annual RPS requirements with new procurements implemented after the effective date of the amended rule. Procurements that would not otherwise have occurred in order to further the outcomes described in section 16.2, 16.4 of the REA. So it's staff's position that incentives can only be earned after May 4th of 2021 with new procurements after that date. Correct?
Well, yes, but I'm reading the rule together with the statute, which if you go to section 62-16-4D as in dog, says that financial or other incentives are provided to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standard, etc. And so SPS, in my opinion, would need to produce or acquire. And in this case, SPS is proposing to simply retire RECs associated with resources that were already produced or acquired. And in addition to that, there's language in the rule under the definition of financial incentive that provides for incentives are provided to encourage certain behaviors or actions that would not otherwise have occurred in order to further the outcomes described in the statute. And with regard to the RECs that are associated with the Hale and Sagamore resources, while I did not participate in case number 17-00044-UT, the case where those resources were approved, it's my understanding that SPS proposed those resources as economic system resources for the economic benefit of SPS and its customers, not for RPS compliance, not in furtherance of the outcomes in the REA.
Have you heard anything today that makes you want to change your opinion?
No, I don't believe so. My other recommendation was that if the commission did not agree with my interpretation of the rule, that the costs associated with the retirement of those Hale and Sagamore RECs should be factored into the net benefit analysis that's required in 17 from the stipulation in 1744. And you know, it's my understanding also that those recs, when SPS proposed that to use them for RPS compliance, they were at no additional cost to the customer. And now this would be creating an additional cost if SPS is awarded an incentive associated with those recs.
And I did see in your testimony that you sort of had an in the alternative argument on page 23, beginning at line 17, that basically that you just explained on the record here today. And what you think ought to happen if, I mean, do you sort of believe that, and I don't know that I ever really understood the expression, but there's an expression that about having cake and wanting to eat it too. And of course, I always figured that if somebody had cake, that of course they would want to eat it. But in that, SPS came in and justified the wind facilities under a certain line of reasoning and evidentiary basis. And now they're utilizing or asking the commission to allow them to get an additional cost from the fruits of that economic justified plant, which you believe if that's the case, then the commission allows that, then the commission should, in its analysis, its net benefit analysis as required in the order that granted that CCN, that the commission should consider that cost that wasn't previously there, correct?
That's correct.
And do you believe that including that would actually lead to a finding of I mean, you say in your testimony on page 24, beginning at line 6, if for any reason the first 10 years of operation for both wind facilities combined does not provide a net benefit for SPS's New Mexico retail customers, then SPS is required to pay to compensate customers for the net cost increase that they've experienced. So if that was the case, then with the way the numbers work, would they zero each other out? I mean, if they got $2.6 million and an incentive, and you included the $2.6 million in the net benefit, I guess to the extent that it might cause a no net benefit, then there's a potential they could have to pay all or some of that back to the ratepayers?
Yeah, I suppose that could happen.
But the philosophy behind you wanting to do this is why?
Well, because based on my reading of the rule, and I don't believe that SPS be earning an incentive for decisions that it made in the past for other reasons and not for RPS compliance, not in furtherance of the outcomes set forth in the REA.
And you would be in a position to know, Ms. Leyva Tercero, has any of the other, or have any of the other public utilities filed for an incentive either before, during, or after the May 4th of this year?
No, not that I'm aware.
I believe Mr. Contreras said that SPS had filed, other than last year when SPS filed for an incentive in their RPS case, that they had done so back like in 2015, but had withdrawn it. Are you familiar with that?
That was my understanding of his testimony, but no, I don't recall that specifically.
Okay. But do you remember their incentive request last RPS case?
Even that's kind of hard to remember with all of the cases that we have going on.
Okay. Well, suffice it to say that the commission did not give them one, correct?
That's correct.
Okay, very well. Thank you. I think that's all the questions that I had for you. Mr. Bagatko, any redirect for Ms. Leyva Tercero?
Madam Hearing Examiner, no redirect, but thank you.
Very, very well. Mr. Du Bois?
No, thank you, Your Honor.
Okay, anybody else? Not hearing anyone, no. Okay, well, you're benefiting, I think, Ms. Leyva Tercero, from the last witness of the day, even though it's Monday and not Friday. So I thank you, and you are excused.
Thank you.
Mr. Bagatko, anything further from staff?
Nothing further from staff. Thank you, Madam Hearing Examiner.
Okay, I believe that subject to, I think, Ms. Lees, I have 2 bench requests that are owed.
That's correct, Your Honor. And I have confirmed with Ms. Leib that the percentage increase was 3.8% that
Okay.
Mr. McMillan asked her about.
Okay, Dr. Lieb says 3.8% on Mr. McMillan's question. And that was a confirmation of his math?
Correct.
Very well. Okay, so that just leaves us to 1 bench request, and that's Mr. Luth, and he's going to give numbers and percentages for the customer classes, typical or representative energy use as set forth in his testimony. And I believe that you all indicated you could do that this week.
That's correct, Your Honor.
Very well.
We will file that bench request into the docket.
Okay. And is anyone going to want an opportunity to question anyone on that? Or can we just accept this without further hearing? Parties.
Madam Hearing Examiner.
Let me just refer to the section I think that section K of 1.2.2.35K, additional evidence. At any stage of the proceeding, the commission or presiding officer may require the production of further evidence upon any issue. Such evidence may, at the discretion of the commission or presiding officer, be in writing or presented orally. All parties and staff will be given an opportunity to reply to such evidence submitted and cross-examine the witness under oath. Does anyone think they're going to need to cross-examine the witness under oath? Mr. Rushoff?
No, Your Honor.
And Mr. McMillan?
No, Your Honor.
Ms. Lynch? Ms. Drake?
No, ma'am. Thank you.
Mr. Pagacko?
It won't be necessary. Thank you, Madam Hearing Examiner.
Very well. Do you think, Ms. Lees, you're going to need to present your witness to provide that information?
No, Your Honor.
Okay, well, I'm going to admit it then. once I get that answer to the bench request. Okay, anything else procedural that we need to deal with before we go?
Yes,
Madam
Your
Hearing
Honor.
Examiner.
Oh, go ahead, Ms. Lees.
I was going to say we probably need to work out a briefing schedule.
I think briefs would be good, don't you?
I do, Your Honor.
In this case, if ever there was a case, I guess we need briefs.
I have worked backwards from December 15th, which is what I anticipate to be the commission's last open meeting hearing this year. I can't imagine that they will have one on the 22nd or the 29th. I guess I don't know, but I would be surprised.
And your guess is as good as mine. Like some of the witnesses, I'm the bosses, I'm not going to put my
I think December 15th is probably the safest bet for us. So I've just worked this out today. Initial briefs due on 10/18, response briefs due November 1st. That as long as we have 3 weeks or 4 weeks between December 15th and the RD, that should work out for exceptions to be filed if necessary. And so I guess that kind of depends on your timing, Your Honor, if you think an RD is possible by mid-November.
Well, you're basically giving me 2 weeks.
That's just my suggestion. I've tried to work within the parameters of when I think this needs to be heard by the commission.
Yeah, I was kind of thinking more, obviously, want the parties to adequately brief this, but I was kind of thinking within what I'm working on for you already and other pending business. I was kind of thinking about briefs on the 22nd and then a week later, response briefs. So, it's actually not that far afield from what you were proposing. What do parties think about that? I mean, obviously, we've got again, SPS and staff had more work to do on reviewing everything for the case that needed to be reviewed. And obviously, as we can all tell from the hearing today, the majority, if not all of the questions from SPS and the interveners had to do with the incentive. So I think your issues are pretty limited in your briefing. you know, with regard to the rule and the statute. And
Your Honor, with
yes, ma'am.
with your suggestion to have response briefs due on October 29th,
Yes.
could we have initial briefs be due October 18th and response briefs due October 29th? That would just give a little bit more time for response briefs. And it still gives 2 weeks for initial briefs.
Well,
Madam,
I'm not opposed, but you know,
Madam Hearing Examiner, this is Joan Drake with LES. I was actually going to say that I would appreciate initial briefs to be filed on October 22nd, given schedules in other matters prior to that.
anyone else want to opine on proposed briefing dates?
Madam Hearing Examiner, I don't mean to cramp Ms. Lee's or SPS's style, but I'm forced to agree with Ms. Drake. I think the 22nd and 29th would be better from my viewpoint and what we've got cooking here at the commission.
Your Honor, I would only ask, do we have an idea of when we'll have the transcript available? I know it's typically pretty quick, but just want to make sure we know that.
And our court reporter, I believe, has we're going to have a expedited transcript, Ms. Gonzalez.
Yes, I've been told 3 days, but I'll try to get it as fast as possible.
Okay. So this week?
Yes, this week.
Very well. So the answer is this week?
Probably Thursday.
Probably Thursday.
Yeah.
I would agree with the 22nd and 29th.
So that's going to give you more than 2 weeks for the 22nd. And really, how much more are you going to say in your response brief than you've already, said in your brief in chief? You know, I mean, I understand rebuttal testimony, but I'm not going to discourage response briefs, but to the extent that you don't go back in your response brief and just tell me everything that you said in your initial brief, I'd appreciate it, especially because of the short time frame that we're going to have, that I'm going to have, that you're, because we start to get, before Thanksgiving, and then we got to start saying, oh, well, I'm going to have to recommend to the commission that we trim your exception time. So I think I'd rather give more days on the front end and cut the response just based on past pattern and practice. Can you live with that, Ms. Lees?
Yes, Your Honor.
Okay. All right. Well, why don't we go with that then? Why don't we go with the 22nd and the 29th for those briefs? And listen to the word brief. So obviously, I want thorough, but thorough doesn't necessarily mean don't give me 100 pages. Don't even give me 50 pages. Okay, let's be as concise as we can, and those will be due by the close of business on those days. Please email me. A motion I was looking for the other day, and I felt bad about. I went back and checked my email. I never got that motion. I was not served. It hurts my feelings when I am not served. I am one of those hearing examiners. I specifically do not put myself on the certificate of service because, quite frankly, I don't want to get all of the emails that you all send back and forth with each other. I mean, that's, You know, I'm not supposed to get that unless it's in the record. I'm not supposed to have it, you know, but when I'm supposed to have it, you want to make sure I get it. And the only other thing would be you need to make sure that I get it in Word format because, you know, that helps me in the drafting of the recommended decision. So any other procedural matters that we need to deal with? Hearing none, let me thank our court reporter, Mrs. Gonzalez. Good to work with you. Appreciate your time. Thank all the parties. We got a lot done here today, and we are adjourned. And I will await your answer to the bench request and your post-hearing briefs. So thank you all very much. Have a good evening.
Thank you, everybody.
Thank you.
Thank you, everyone.
Okay.
And Melissa, anything
Yes.
you need, just let me know.
I will. I'll email you if I have a question or
Okay.
something, but I don't anticipate it right now. So,
Okay.
all right.
Very
and
well.
I'll get this as soon as I can. Maybe in advance of Thursday, but there's a lot to go through. I want it to be good. So
No, that's absolutely fine. I mean, we did go through a lot of things, and so I think
sure.
I think whenever you can get it is absolutely fine.
Great.
And thank you very much. I appreciate it. Look forward to
You're
seeing you
welcome.
again.
All right. Thank you so much.
Okay. Bye-bye.
Bye-bye
Let's see if
now.
I can figure out how to I'm